Welcome to Looking at Legal Stuff. Today we have part 8 of an 8-part minor guardianship case consisting of 16 hearings, including 2 trials, the second of which is 4 days long. At the start of this case, the paternal grandparents already have physical custody of the child because Dad left his daughter with them after they kicked him out of their house for not taking care of her or following their rules. But this was not a court-ordered guardianship, so when Dad showed up at their house after 6 months of no contact and wanted the child back, his parents panicked and filed for a full legal guardianship. Dad is fighting the guardianship tooth and nail, claiming he's finally ready to be a good parent. The guardians claim that they have never kept their son from seeing his daughter, and they want him to take care of her, but they also want to make sure that he has the skills and resources necessary to do that first. They claim that Dad has always been a lazy and neglectful parent who has pushed off the care of his child onto the women in his life, and they're extremely worried about just handing the child back over to him because Dad, who is 23, currently lives with his 52-year-old girlfriend and her sex offender son, who isn't supposed to be around children. Are Dad's claims that he has a plan to keep the child safe and healthy going to convince a judge? Let's find out. This case will be broken into 8 different 3-hour videos, so make sure you watch all 8 parts to see the full story.
All right, good afternoon, everybody. Let's go ahead and reconvene. We're ready. Looks like we have both attorneys here. Appreciate that. And then looks like Mr. Ludwig, Jaden Ludwig is present for the, for the redirect, or well, actually we need to finish up on cross, I think. So thanks for that. I appreciate that. We'll go ahead and get started. Any items to address before we get started?
No, Your Honor.
None for me, Your Honor.
Okay, great. Thanks. Okay, welcome back, Mr. Ludwig. We'll go ahead and continue with the cross-examination. Ms. Winkles?
Okay, yes. Concerning the visitation you've had during the minor guardianship, about how many times would you estimate you did a no-show or you didn't show up and utilize your visitation?
Maybe twice. That's due because of money, because I got every time I miss a day at work for court, that's another day I'm missing money.
Okay, and so would you say that the list that was typed up in the trial brief was correct?
Some of them, like I said, there's like 2 of them that I didn't show because of I didn't have money that week, but I did try to make them up.
Okay.
When
let me just move on just so I can get it. What was the reason you were late so often?
So often that's traffic. There's some major stuff going on in Portland. Construction's going on in Portland. A lot of like construction weather was so bad. It was raining so bad that it's hard for everybody to see. So everybody was slowing down. It's all due to like traffic and weather is the reason why I'm late.
Okay, and initially on the last hearing, when you were asked what you wanted to see happen with the end of this case, you stated that you wanted to see overnights. You wanted to have overnights. Is that still the case?
No, so that question kind of got me. I kind of got backwards on that question. What I want to see is that I want.
You're muted.
Yeah, I got a dog that's yapping, and I didn't want to have that interfere with the whole thing. So I was just trying to be nice about that. I want Jalen back into my custody. I just that the question that I answered that way is because I thought it was something to do with what do I wanted to see with the visitations. That's what I thought that question was asking.
Okay. And was there a reason that you had over 10 no-shows for calls?
Yeah, so I was working over at Domino's, and that's a swing shift, and 7 o'clock is usually the times that I'm still at work. So it's not like I can go off and say, oh, I got to go do this from work and then go do it. That's an easy way to get fired from a job. Okay.
And kind of bouncing around, these are just my final questions. Now, you were specifically asked not to smoke marijuana at the home of Kai Ludwig and also at Michelle Harrington's house, correct?
No, not at Michelle. No, Michelle's Harrington house. That's what you're putting words. You're putting words in words.
Okay, so you're allowed to smoke at. I'm sorry, you're allowed to smoke at Michelle's house. I think is that correct?
Yeah, I can when I do when I do it at
Okay.
night.
It,
When I
were
smoke at
you
night, yeah.
asked, sorry, I got the name wrong. Were you asked not to smoke at Melody Boone's house?
So I was asked not to smoke inside,
Okay.
not outside. I was able to smoke outside. She didn't care if I smoked outside. Her daughters smoke. So I don't so that's kind of hip.
Okay.
I'm just gonna leave it at that.
Okay. So, would you consider Melody's testimony? She stated that she had significant problems with you, that you were neglecting the child. We've heard testimony from several people who have witnessed you parent the child and said that you didn't change the child, you didn't take care of the child, you essentially let other people take care of the child. Are they all lying?
Yeah, so I wouldn't, it's not that I wouldn't take care of my child. I would, I was taking care of my child. I was taking care of Jalen before I moved into Melodies, and she was fine. She was taken well care of. She was well taken care of for those 2 years that I've had her. She wasn't mistreated. She wasn't neglected, you know, that's the reason why I got Jalen in the first place, is because her biological mother neglected Jalen.
Okay, I have one final question. So in this case, you've testified that you were told that you were going to be homeless unless you left the child. So you chose to leave the
Right.
child and take the train ride. If Michelle or your grandmother tell you the same thing, that you're
So
going to leave, that you have to leave and that
I
you'll be homeless or you'll lose the child.
I did meet
What are you
Michelle.
going to do?
Mr.
Are you
Mr.
gonna-
Ludwig,
let
Mr.
me try.
Ludwig, Mr. Ludwig, you can't interrupt. You've got to wait for her to finish the question, and then you can answer the question. Don't anticipate what she's going to be saying. It sounds like you've got a lot to share, but you have to wait until the question is asked, and then you can answer. Thanks.
Okay, so let me try it again. So if Michelle or grandma tell you that you're going to be homeless and that if you don't leave the child, you'll essentially be homeless. Are you just going to leave the child again with somebody else because nothing has changed from the time that you lived at Kelly's house to now?
Aaron, I would really like you to ask that question in a different way, because you got the names wrong.
If Michelle, your girlfriend,
I did not meet
kicks
Michelle.
you out,
Meet Michelle Harrington.
if
Mr.
Michelle
Ludwig,
Harrington,
Mr. Ludwig, the
no,
question is going to be posed to you, so I need you to stop talking. The question is going to be posed to you, and then you can answer. We want to hear your answer, but you need to hear the question first.
Okay, my answer is no.
okay.
I guess
So-
I need to know what the question was.
Yeah, so if Michelle Harrington or your grandmother tell you the same thing that Kelly did, that you're going to be homeless unless you leave the child with them now, are you going to leave the child with a third party again? Because your circumstances are the same.
My circumstances are currently not the same, and no.
Okay, you currently have less than $500 in the bank, correct?
Yeah, that's because if you guys look, I drive up every weekend,
Okay.
and if you guys check on the gas prices every weekend,
Hold on.
else,
You have $500 in the bank. You're not on any rental agreement, correct?
currently, no, I'm not on a rental agreement. Trying to get there, but
So you make about $1,500 a month, correct?
And well, I'm trying to answer that first question, and you're going to put other questions in front of that question. The question that you were asking about, will I leave Jalen? And the answer is no. I'm not going to put Jalen in anyone else's care but my own. I'm a reasonable and responsible adult now. I'm learning. I'm still learning. Yes, I'll give you that. I'm still learning. There's a lot more stuff to learn, but I'm still learning. There's more time in my life that it's not like I'm going to be dead tomorrow. I'm trying to get everything that I can take care of my kid for as best as I can, right at the situation and the situation that I have currently right now with what's going on with finding an apartment, for driving up there every weekend. For me, driving up there every weekend, that's spending quite a bit of my money. You know, I gotta get Jalen. I feed Jalen. I buy food for Jalen for like vegetables and fruits and stuff like that. So she's eating healthy. So all my money that I'm trying to save, that's kind of hard for me to do right now if I'm doing weekends every weekend. So
Do
I'm
you,
trying my best. I'm trying the best that I physically can right now with the amount of for pricings of everything else. I'm trying my best to do everything I can physically, mentally, and emotionally to take care of Jalen Ludwig.
okay. Your Honor, I'd ask, I'm pretty much done with the questions. I'd ask to admit some exhibits, to do some cleanup here. I'd ask to admit Exhibit 3, the sealed supplemental guardianship report.
Okay, let's see, just one second. Let me ask Mr. Anagnostou while I'm looking for that. Do you have any objection to that?
What's the policy? I mean, do we admit the guardian ad litem report or take the testimony from them on?
Well, the report's already admitted under ER 904. This is just the
Right.
supplemental.
Okay, so is the supplemental, was that submitted under ER 904?
It wasn't, it came out after
Okay.
that. I did ask the guardian ad litem about it, but I didn't request at that time to admit it into evidence.
Okay, and Mr. Anagnostou?
Yeah, I guess I would object based on that it wasn't discussed during the trial.
It
And-
was discussed. I just didn't ask the court to admit it at that time. But I did question on it and ask what it was and authenticate it.
And we had the guardian ad litem testify.
Yeah, and I can call her back if she's here, she's listening on YouTube. That makes it easier.
Okay, so as far as the admission of Exhibit 3, I'll deny its admission. She was here to testify, and I think that's the better course is to examine a witness rather than the written word or maybe a duplication.
Okay. Exhibit 7, the text messages between Kai Ludwig and Teresa Ludwig. I asked both of them about it and they both authenticated them. That was number 7.
Okay, Mr. Anagnostou?
No objection.
All right, 7 is admitted.
Number 6 was ER 904. Oh, sorry, my apologies. Number 4 was an ER 904, so that should be admitted. There's no objection. Number
As
6.
the temporary guardianship affidavit.
Yeah.
Yeah.
Any objection to that, Mr. Anagnostou?
No, Your Honor.
4 is admitted.
Number 6 was ER 904 as well.
Any objection to number 6?
What is number 6?
More text messages between Kai and Teresa.
No objection.
Okay, so 6 is admitted.
Number 8 was also under ER 904.
Number 8. The Progress Center evaluation.
That's correct.
Any objection to that, Mr. Anagnostou?
No, Your Honor.
Right, number 8 is admitted.
Number 9 was also under the ER 904.
Let's see. I did a keyword search under my notes and I'm not finding an exhibit 9.
That's because we called it something else.
Okay.
Yes, under the ER 904, and I can go there now. Bear with me. Let's see, where's my ER 904? Let's see, what was that?
So
Number 9 was, we called it something else, but it appeared to be the same document. It is, let's see.
I'm not sure what 9 is, but I would object that it's hearsay. It looks like some DSHS document.
It is, it was actually attached to the other one. It's the We Care document. Hold on, I can pull up the ER 904 right now. You know what, I'll just skip that. I'm already, I think it's attached to somewhere, but I'd have to go through 203 things, so I won't, I don't think it's probably that important. The certificate of immunization status, number 10, that was under the ER 904 as well. That was number vaccination record. That was number 6. It was called the vaccination record under the ER 904.
And
Not
it
sure
was,
when they changed their names.
and it was referred to during the trial as Exhibit 6 or 10?
It was referred to as Exhibit 10.
Exhibit 10.
My apologies. I had new staff, so it's a learning process. The ER 904 to the trial brief.
So Exhibit 10, I did a keyword search in my notes. I didn't find that. And you said it was a vaccination record?
Yeah, so it's the same. Exhibit 10 is Exhibit 6 in the ER 904. They called it the vaccination record of Jalen Sloan versus the certificate of immunization status.
Okay, so maybe I should look for Exhibit 6.
Yeah.
So Exhibit 6, we admitted that. It looks like those were text messages between
Yeah, Exhibit
I
6 in the ER 904.
904.
Yeah.
So was it addressed in the trial today as Exhibit 10?
It
Yeah.
was not, it was specifically spoken of the vaccinations, but we didn't refer to that. We referred to the vaccinations, but not the
Okay.
document itself, but it was
Okay.
under ER 904.
Okay, so it came in under ER 904. So for purposes of looking at that document, it would be marked in, at least in the book that I have here, as Exhibit 10.
Correct.
Yeah, so
Okay.
in the book, it's Exhibit 10. In the ER 904, it's at page 71 of the exhibits, and it's called, and for some reason, I'm not sure why, they put it as the vaccination record, but it's the certificate of immunization status in the trial brief.
Okay.
Same pages.
Okay, thanks. Mr. Adagnato, any objection to that?
No, Your Honor. It's the child's medical records.
Thank you. Exhibit 10 is admitted.
Exhibit 11 is the We Care daycare sheets, which is also under ER 904. Sorry, my cat is screaming. I apologize. Trying to find the.
Any objection to that record, Mr. Adagnato?
No, Your Honor.
Okay. I won't look
So
for it.
Exhibit 11 is admitted.
Exhibit 12 was also in the ER 904. It's the notice of discontinuation from the treatment center, the Progress Center.
Any objection to that, Mr. Adagnato?
No, Your Honor.
Okay, 12 is admitted.
13 is, well, I don't, the interrogatories, I'll skip that. 15 is the text messages between Jaden Ludwig and Kai Ludwig, dated October 1st through April 16th of 2023. That is not in the ER 904.
Okay, Exhibit 15. Bear with me just a moment.
And it is not in the ER 904.
Mr. Adagnato?
No objection.
Okay, so exhibit, let's see, just one second. I lost my,
15.
yeah, thank you. Give me just one moment.
Mhm.
Sorry about the delay. Let's see. Okay, so I'm ready. Thank you for the pause. Exhibit 15 is admitted.
Okay, skipping exhibit 16, exhibit 17, the visit log notes, and that was under ER 904 as well. And hopefully it was called the same thing.
Okay, any objection to exhibit 17 being admitted?
No, Your Honor.
17 is admitted.
Okay. 18 was not in the art. I will skip that as well. 19 is the text messages between Michelle Harrington and Kelly Crape, and that was under the ER 904 as well.
Any objection to that admission?
No, Your Honor.
19 is admitted.
Okay. 20 are additional text messages between Michelle Harrington and Kelly Craig, just a different date, and that was under the ER 904 as well.
Any objection to their admission?
No objection.
20 is admitted.
Number 21 is text messages between Jaden and Kai Ludwig. This was not in the ER 904.
Was it addressed in testimony today?
It was. We specifically asked questions about it.
Okay.
I don't recall asking questions about this, but I have no objection.
So with exhibit 21, without objection, it is admitted.
Exhibit 23 is not in the ER 904 as well. And I did ask Kelly Crape about that one, number 23.
All right, Mr. Anagnosto. I was looking at my notes. I didn't see a direct reference to 23.
It's not a direct reference. I asked, essentially I believe it's about being late and showing up. It was about tardies to visitation.
Okay, and is it some type of just a visitation log?
Yeah, it's just
Yeah.
it's Kelly and Jaden speaking to each other about visitation. Obviously
Just
my
text-
client wants it in, but it doesn't need.
Text messages again?
Yeah.
Okay. Mr. Anagnosto,
No objection.
23 is admitted.
Okay, let's see. 29, exhibit 29 is just a Google Maps image with the distance between Kelso and Toledo, Oregon. It was under ER 904.
Mr. Anagnosto, any
No,
objection?
no objection.
29 is admitted.
Okay. Let's see. Exhibit 30 is information pleading dated February 4th, 2011. It was under ER 904 as well. And make
Any
sure.
objection to the admission of exhibit 30?
Maybe looking at the, oh, yes, it was number 21 in the ER 904.
You may have already mentioned something, Mr. Anagnosto. Do you have any objection to that?
Yeah, my objection is that I don't know that we discussed this, and I'm not sure. I mean,
I can wait on the rest.
who this even is dealing with. I mean, as far as I can tell, it's not any part of this case.
Okay.
Oh,
I can wait. The remainder, I believe, Your Honor, are actually, oh, there's a few more, and then the remainder I can do after Michelle Harrington's testimony. Let's see, that's Michelle Harrington. Exhibit 34, the Google takeout, it's not part of ER 904, but we did specifically reference it.
Any objection to admission of exhibit 34?
Yeah, I object to 34.
So exhibit 34, there's the Google takeout. That's where I don't think that exact document was at least referenced by its exhibit number. I remember questions of Mr. Ludwig related to whether 420 holiday or Chipotle or the like.
Yes, bait stamp number 493 was the page that was specifically referenced.
Okay. So there's a motion to admit and there's an objection. I'll sustain the objection, improper foundation or lack.
Okay. Number 35, respondent father's Wells Fargo. Not part of the ER 904.
Those are the bank statements.
Yeah, bank statements.
Mr. Adagnosto, any objection to the admission of exhibit 35?
No objection, those are.
35 is admitted.
Okay. Number 39, the sheriff's report for the incident in June 12th, and it was under ER 904.
And just going back again, exhibit 35 was the Wells Fargo bank statement, correct?
That's correct.
Okay, so now we're talking about exhibit 39, which is the police report related to the graduation incident.
Yes, and that was under ER 904.
Okay, Mr. Agnosto.
And I think it was identified by the officer as well, so I think that gets admitted.
39 is admitted.
Exhibit 43 was also ER 904 admitted. It's just a picture of the child.
Any objection to the admission of exhibit 43?
No objection.
43 is admitted.
Okay. Sorry, going back. Exhibit 40 was the Google takeout search data with regards to, I think this one was the puffco.com. It was not part of ER 904.
Any objection?
Yes, Your Honor, I'd object to that.
I'll sustain the objection, improper or lack of foundation.
Okay. 41 is going to be the same thing.
And that's also a Google takeout.
It is. It is.
Okay, any objection to
Yes, Your Honor.
Okay, 41 is also not admitted.
Okay. Finally, exhibit 44 is the urine drug test. It was not part of ER 904 as well.
Mr. Agnosto,
No objection.
44 is admitted.
And the remainder I can request after speaking to Michelle Harrington.
Okay, all right, very good, thank you. So that finishes the cross-examination of Mr. Ludwig. Then we'll turn the time back to Mr. Adagnosto for redirect examination of his client. All right, Mr. Ludwig, you ready? I'm making an assumption, Mr. Agnosto, you want to address some issues on redirect?
Yeah, just a couple.
Okay, all right. Mr. Ludwig, you still there?
Yes, I am.
Perfect, great. Go ahead,
Okay.
please, Mr. Adagnosto.
Jaden, just a couple of things. When counsel was asking you questions, given your plan of living in Toledo, Oregon, she said you would be waking up Jaylyn at 5:30 in the morning. And I think you testified on direct differently. Would you be waking her up at 5:30 in the morning?
About 5:35, maybe 6. It's just, you know.
The question is, are you going to wake her up? You testified.
I'm the one that's gonna be waking her up.
No, you're up, but is Jaylyn up?
If she's awake at the time, then she's awake at that time.
Okay. Do
She's
you know
like-
what her hours are now? What time she gets up to go to daycare?
What I understand from Kelly or Kai, that she gets up around that same time.
Okay.
It might not be exactly that same time that I'm saying, but it's in that time frame,
All right.
you know.
And so this is getting her up at, or her waking up at 5:30 to go where?
I would be to get ready for dress, everything else like that, to go to daycare.
Okay. And the question is, how long do you plan on doing this in Toledo while you're working in Silverton?
So with my plan, which is I'm gonna stick to it, is I'm gonna try to find a place near my workplace. It doesn't have to be in Silverton. It could be in Salem near my job. It's still closer to my job. Um, you know, um, I'll be able to get. Hopefully, I'm trying to get into an apartment or try to get into low income housing, which I've done some applications. I just have to turn them in, but I'm doing that. Um, I'm going to be taking parenting classes, even though I don't feel like I really need to take parenting classes because I did take care of Jalen for the 2 years. But if the judge does decide for me I have to take parenting classes, I will go ahead and follow that rule and do my parenting classes. And I mean, like I said, I have a parenting class that will be starting in October. Um, those are the steps, that I'll be doing. And if Jaylen needs to go to the doctor, she'll go to the doctor. If she hurt her arm, she's going to go to the hospital or the doctor or urgent care. Where if it's really truly hurting, it's broken, she's going to the hospital. Obviously,
Right.
she can be well taken care of. She can be well fed. Um, I don't have a kitchen up in Long Beach, so I can't cook her home cooked meals like I want to. Um, so you know, at this
Right.
moment in time, the fast food joints are and besides what I bring up, like carrots and stuff like that. It's just that's what I could do at this time because I don't have a home to go to cook her food. I
Right.
don't have a home up there or a place to rent up there to do majority of all the parenting skills at this point. But when I do get my child back, which when I do get Jalen back, and if I do get Jalen back into my custody, I will be doing those said things. I'll be taking care of Jalen. They'll be all on me. I'm her father, and as her father should take care of Jalen.
Do
Take
you
care.
have, do you have a timeline for you to be able to find housing for you and
Um,
Jalen?
so if I'm on the housing waiting list, the waiting list on the low income housings, those do tend to take a little while, but I'm still going to be looking into finding an apartment, rent to own, or something that I can get into for Jalen. So
Okay.
I'm not going to not stop looking. I'm going to keep looking. It's just at this time with my going up and visiting Jalen every weekend, it's kind of costly on my end, and it's kind of hard for me to save money right now.
All right.
I'm trying
There,
my best.
council was asking you a lot of questions about your parenting class, basically criticizing the class that you took. How did you find this class?
So that 4 hour long class, I do believe I did find it online. I didn't know that it was for divorced children. I didn't know. I just thought it was just a parenting class. So I took said parenting class. Um, online. So I mean, I did do those. Did do the online classes, but if that since that was found not acceptable, then I went ahead and asked Sherry Farr which other um parenting classes is that she wants me to take, and she gave me a list of parenting classes. And this parenting class that I'm gonna be doing in October is I found it out through Sherry Farr is the one that I'm doing in October.
Now, when you got custody of Jalen from Oregon Child Protective Services, uh, were you required to take any kind of class before you got custody of her?
No, I did not. They didn't tell me I had to take any classes or anything. They just I signed the document over. So that way it's my name's on that document, and they gave me her right then and there.
All right, and then,
Instant transaction. I didn't have to take parenting classes, then go get her or anything like that. I just got her.
okay,
So
and uh, how do you feel the care you've given Jalen has been?
it I mean it could be better, but like I said, I'm only 23 years old now. Um first child, it's not like I have 20 or 5 or 4 or whatever. this is my first child. Yeah, I'm gonna make mistakes here and there. I bet you anybody's parents back in the day, or even today, this year, are still learning how to do things. They don't have it right away from instantly. Oh, I got a kid. Boom. Okay. Boom. Oh, I gotta be a parent. I gotta I gotta do everything that I already know how to be a parent. No, I was a child. Then I was a parent. I mean, I'm just trying my best and to my knowledge that I thought I was doing everything okay. So maybe I was, maybe I wasn't. I was I was still trying to learn how to become a parent.
Right. And I guess the final question is that Jaylyn has not been to Michelle's house, correct?
Yeah, she's never been here. She never will be coming here.
That's the
I,
question. Okay.
She's not going to show up here. I will not let that happen. I will not let my child be around, people that are not supposed to be around people, kids or anything. I'm not going to put anyone into danger. I'm not putting my child in danger. That's my first key. My child is not going to be put into any type of danger, not whatsoever. I kind of know how to read people. If I feel like it's a bad person to be around Jalen, even though I just met him, then I'm not going to, not going to have him around Jalen. I got to meet the person before even if she's there, but she's not going to come here. She won't come here, but she won't, anybody that's new is not going to be around my child right away. I got to get to know him before or anything,
I don't think I have any other questions, Ron.
All right, thank you, Mr. Agnostu. Ms. Winkles, any recross examination?
Just one question. Are you aware that according to the We Care daycare records, the child didn't even go to daycare till 9? So what leads you to
9
believe
what, 9 months?
9 a.m. on average? So what leads you to believe the child was up at 5?
So Kelly gets up and has to be at work at 7, right? Is that correct?
So during this format, the attorneys ask questions and you provide answers.
Right.
It's not a time to ask questions of the attorney.
And just so you're aware, at that exhibit 11, we have Kelly Crape's time card as well, and it shows her getting to work at 9 a.m. So what would lead you to believe the child was up at 5?
Them saying, I don't know, them telling me that they get her up at 5, get her up at 6 a.m., get her up at 7. If I get her up at 7, I can't get Jalen up at 7 because I have to work. I have to be at work by 6:40. So in order for me to, as a parent, and what a parent would be doing, would be getting her up and doing those things, trying to make sure she's ready for school and everything, while I have the opportunity and the time to do so as a parent. I'm not going to have anybody, do it for me. I'm not going to have anybody take care of my child without, for me. It's my responsibility. And if I get up at 6, if I have to get up at 5, yeah, I'm going to try to get her up and get her ready for everything that she needs to get done and get ready.
No further questions, Your Honor.
Okay, thank you. All right, so that concludes the testimony of Mr. Ludwig. Thank you, Mr. Ludwig. Mr. Agnostu, would you like to call your next witness?
Oh, yes, Your Honor. I'd call Michelle Harrington.
Okay, Ms. Harrington, if you could turn your camera on and unmute, please. All right, Ms. Harrington, if you'll please raise your right hand, I'll administer the oath. Do you solemnly swear or affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Will you please state your full name and spell both names, or all names?
Michelle Lee Harrington, MICHELLEEHARRINGTON.
Great, thank you. Mr. Agnostu.
Yes, Ms. Harrington, where do you reside?
I reside at 443 North James Street, Silverton, Oregon, 97381.
Okay. And how long have you resided there?
Since March 2004.
Okay. And who else resides there?
My son Tyler Harrington lives here.
Okay. And it's our understanding that your son has been convicted as child, some kind of child issues.
Yes, correct.
What is his conviction?
He was convicted of 2 coercion, and I don't recall what the third charge was, but he is a registered sex offender. Yes.
Okay. And my first question is, has Jay Lynn Ludwig ever been to your residence?
No.
Okay. Is there any possibility of her coming to your residence?
No.
And why is that?
Because I will not put a child in that situation. Not my nieces, nephews, not my grandchildren, not Jalen, not anybody, or put my son in that position where he is doing something he's not supposed to do. No, I will not let any child be here in his residence or in his when he is here.
There's been an allegation by the plaintiff's attorney that you're looking out more for your son than Jalen. Is that a correct allegation?
I look out for all children, any minor that would be in in the wrong situations. It's not just my son I'm looking out for. I am looking out for Jalen's safety as well.
Okay. Is your son still on supervision?
Yes.
Okay, so does a corrections officer stop by periodically?
Yes, unannounced. And they have recently did that.
Okay, all right. There were statements and declarations to the court that Jalen had been to your house. I mean, they were definite statements. What's your response to those?
I was very upset about it because there was no foundation for that. There's no proof that she'd ever been here. Jaden's Google takeout never showed that he was here during visiting hours. So I was, like I said, I was very hurt and upset that they made those allegations without any proof.
All right. You have seen Jaden with Jalen during some of his visits.
Yes, I have.
Okay. Can you describe for the court the relationship he has with his daughter?
I think it's really sweet. She dotes on him very much, and he dotes on her. It's very clear that she knows he's her father. She's very attached to him, and they get along great. She loves to play. They were playing peekaboo yesterday at the park, and it was really, really cute to watch them be together and play together, and the way that she just loves on him.
All right. And how is his care of Jalen?
For his age that he is as a young father, I think it's spot on. I mean, he's trying his very best, and if he doesn't know what to do, he knows to ask. And I'll give him any advice and that I know to give him if he, when he asks.
Okay. Now, you have been at some of the visits, but not all of them, correct?
I have.
On those visits, was there any concern with regards to Jalen's cleanliness, being wet, that kind of thing?
No, Jaden has a backpack with appropriate clothing. He brings wipes and sunscreen and picks up after her if she's spilled her food or made a mess, changes her clothes, cleans her up.
All right. And I guess that's the question. During the visits, who is doing the care for Jaylyn?
He is.
Okay. The petitioners have gone kind of back and forth about whether you should be there or not. In some instances, they indicated that it was actually good that you were there, and in other instances, they wanted him to have the visits alone. You're aware of that, right?
Yes.
Okay. What's your reaction to that? I mean,
After hearing Kai's testimony last time about him not being able to, I think you had asked about them not being able to provide proof that she'd ever been here, about whether he'd take his statements back about me being a good person. It really hurt me, so I stopped going to the visits, which, and you know, I was upset with that. And yeah, I don't know. Jaylyn's, you know, a sweet child, and I try to provide Jaden with as much advice and support that I can.
okay.
But you know, I love to go up and visit with her. I love to spend time with the two of them. But you know, and there's often times where I'm not able to go. I have other obligations here with my grandchildren or my son on the weekends. So it's not just that I don't want, you know, don't go to make him have alone time. It's because I have other obligations on the weekends as well.
He is working near your home, correct?
Yeah.
And
Yes.
who does he work for?
Forest River.
All right. And how is he, what time does he go to work?
He leaves here about maybe 6:40, 6:45.
All right.
I'm not always, sometimes I'm still sleeping. So, you
Okay.
know,
And so how often does he do that?
every day,
Okay.
Monday through Friday.
There's been allegations in this case that he sleeps in, doesn't get up in the morning. Have you seen that?
Only on the weekends when he's not going up to Washington. His job is a very physical, demanding job. So I'll let him sleep in so that he can be physically rested.
All right. On weekends.
Uh-huh.
But all right. And then there's allegations about cleanliness and taking showers and those type of things. What's your observations?
He does shower.
How often?
If not every day, every other day.
Okay. Do you have any issues of, I mean, they were describing not smelling good and those type of things, and
No, I don't have any issues. He washes his laundry. So, and he bathes,
all right.
washes.
All right. During the visits that you've accompanied him, how was his care of Jaylyn?
Good. He's very hands-on. He dotes on her, pays attention to her, you know, takes care of her needs.
All right. There's been, you know, some kind of, to a certain extent, speculation that you were providing the care during the visits. Is that correct?
No, not all the time. No. You know, there'll be certain instances where I have taken her to the restroom with me, but that would be because I need to use the restroom. So it's just a knee-jerk reaction for me to ask her if she needs to use it and then take her with me. If Jaden doesn't feel comfortable taking her into the men's restroom, then sure, I'll take her into the restroom. You know, if I'm getting up to get some food or something like that, you know, it's just, as a mother myself, it's just a knee-jerk reaction for me to ask a child if they need anything. I'm not going to ignore the child. If she's asked me for something, I'm going to get it for her. I don't want to be shown as ignoring her. That's just not who I am.
On the occasions that you accompanied Jaden, what was Jalen, how was her reaction to Jaden?
It's really sweet. She just very much, you know, she runs to him, hugs him, and wants to be, you know, in his presence all the time.
Oh, guess what? Looks like Ms. Winkle's dropped off and I just saw.
No, I'm here, but I froze, so I thought it best to secure a backup so that
Oh, okay,
there's no lag.
good, thanks. So we're okay. Thanks.
Yes.
Sorry for the interruption, Mr. Adamastu.
No, that's fine. There's been an issue with regards to Jaden taking a parenting class. Is she still here? Oh, there.
Yes.
Are you aware of Jaden taking a parenting class?
Yes, I remember him telling me that it was a 4-hour course. And yes, he sat there for 4 hours on his phone.
Okay. I guess the question is, do you think he needs a parenting class to parent Jalen?
Having some extra resources or information on how to be parenting is never a hinder. It should, I mean, it shouldn't be judged about taking a parenting class. He could always learn more. I'm sure of it. There's no harm in it. No harm, no foul.
Should he not have custody until he has completed some kind of parenting class?
That's not really for me to determine, but what I can tell you is that he does an excellent job right now. And he knows he has resources that he can ask if he needs some help, but it shouldn't be, it's not for me to judge.
I don't think I have any other questions of this witness, Your Honor.
Okay, all right, thank you.
I'd like to just note, this is the time that
Oh,
my son,
Ms. Harrington, I apologize. So the next stage of the proceeding would be Ms. Winkle asking questions of you on cross-examination. Thank you.
Okay, so you stated that you haven't been going down for the visits, but you were there this last weekend, weren't you?
yes, I think that was the first time I'd been there in quite a few weeks.
Okay, and the grandma had been taking him, isn't that correct?
She took him on, yeah, she drove him up there Saturday morning.
Okay. Concerning the amount of funds that go back and forth, about what would you say on average is how much, let me rephrase that, each month on average, about how much do you give Jaden?
Maybe less than $50. I think on the bank statements that we submitted, 13 months of bank statements, it averaged out to be less than $52 a month.
Okay. And in December, it was considerably more, correct?
I honestly don't recall. I have to look at my bank statement as well.
Okay. We have the bank statements here and it looks to be over $300. Do you remember that?
I don't recall, no.
Okay. Do you pay for other things for him?
For him?
Yes.
No, he has a job, so he can take care of him.
Who pays for his car insurance?
He does.
Okay. Who purchased his vehicle?
He did.
Okay. You pay for the hotels for the visitations, correct?
We both do on occasion. We all,
And,
three of us, we share.
okay. And the grandmother's pay too, correct?
She has, yes.
Okay. Do you also buy him marijuana?
No,
Okay. And do you provide food for the house?
we all do, all three of us.
Okay.
Three of us.
And you guys, how long have you guys been dating?
2 years.
Okay. Are you guys going to break up when he moves down to grandmother's house?
No, we don't plan on it.
Okay. How long has he lived in your home?
Well, he started his job in February, so he's temporarily resided here since then.
Only since February.
I believe so.
Okay. So he would be wrong if he answered a discovery request in May stating that he'd lived with you for over 5 months. That's not accurate.
5 months of last year or this year?
So he's stating that he moved in there at the beginning of January. Essentially, I mean, he said 5 months and it was answered in May, so I'd assume he meant January or December.
2023 you're talking about.
Yes.
No, then he may have. I mean, he started his job the 1st of February, so he would have applied maybe at the end of January. So maybe that's possible.
Okay. How'd you guys meet?
Through an online dating app.
Okay. And how many times had you seen each other in person before he moved in?
I'm sorry. Can you say it again? I'm sorry.
How many times did you have in-person contact before he moved in?
Well, we've been dating for 2 years, so we've, I would go down to the coast to see him. He would come up here for a few days.
Okay. I have 1 second. Does he smoke marijuana at your house?
Yes.
Okay. About how often does he smoke marijuana throughout the day?
Well, he works all day, so after work, after he gets home at 3:30, 4 o'clock.
Okay, I have no further questions. Oh, actually, hold on, I take that back. Do you have the exhibit book in front of you?
I do not. I'm actually in my vehicle because I need to take my son to work.
So we're not gonna have any witnesses testifying while driving. So Ms. Harrington, you'll have to pause your driving for a bit until you're finished testifying, please.
I'm really sorry. My son has to be to work in 20 minutes. And I was not expecting court to be this long, so I had not made any arrangements for him to go to work.
I don't think
sorry.
I don't think we're going to be much longer. Could you postpone it 5 minutes, please?
He's getting out of the vehicle. Okay.
I'm just going to ask you concerning the text messages that we put in between you and Kelly, where you talk about different times that you're going to be there and different times that you're late and asking for things. Did those text messages look truthful and accurate to you? Did they look like the text messages between you and Kelly?
Sure. Yeah.
Okay. And it's a little difficult because you don't have it in front of you. And concerning the, bear with me 2 seconds, I'll try to make this very quick. Concerning the Google takeout search information where it appears that he's going to Puffco. He said he didn't buy that Puffco vape. Did you buy the Puffco vape?
He got that as a gift, but I don't recall that who gave it to him.
Okay. Do you remember him searching for it on his phone?
No.
Okay. Do you have you ever seen him use his phone for online gambling?
No.
Okay. Let's see. I think, Your Honor, I can let her go. I don't. Oh, actually, the sex offender information that we put into, I know you don't have it in front of you, but the sex offender notification news release and the information about his case and his petition to enter a plea. Did you review those?
Yes, I have.
Okay. And are those accurate? What we put into the file, are those accurate for what they state? Essentially his crime, what he was accused of, what he pled guilty to, and all of the other information within those.
Yes, they are.
Okay. Your Honor, I'd ask to admit in that case, those exhibit, unless you need additional information, the exhibits, the 31, which was in the ER 904, 32, and 33, which were in the ER 904 as well. Additionally, the text messages between Michelle and Kelly, which were 19 and 20, I'd ask to admit those. And 19 and 20 were also part of the ER 904.
Mr. Adagnosto, any objection to exhibits 19 and 20, which relate to text messages between Ms. Harrington and Kelly Crape?
No objection.
Okay, 19 and 20 are admitted, and then related to exhibits 31, 32, and 33, there's a motion to admit those. Any objection to those?
I would object to those, Your Honor.
Okay, 31 and 33 were submitted under ER 904. Ms. Winkles, is that correct?
That's correct.
31 and 33 are admitted. What's the basis of the objection to 32?
No objection. It's just charging statement, so it's public record.
32 is admitted. Now we'll turn, any additional questions, Ms. Winkles?
No, Your Honor, no further questions.
We'll quickly turn the time back to Mr. Adagnosto for any redirect examination.
No questions, Your Honor.
Ms. Harrington, thank you very much. You're excused. Thank you. Okay, Mr. Agnosto, any additional witnesses you'd like to call?
No, Your Honor.
Okay. Ms. Winkles, any rebuttal witnesses you'd like to call?
No, Your Honor.
Okay. Let me touch base with the parties as far as the closing argument from the parties. Would you like to have maybe 10 minutes to gather your thoughts, and then or do you want to just jump right in right now?
What would Your Honor prefer?
I don't care.
I would love to take 10 minutes in that case.
Mr. Agnosto, you're okay with that?
That's fine.
Great. We'll be back at 2:30 for closings.
Thank you, Your Honor.
See everybody then. Thanks. All right. So I think we're ready to hear from the parties as far as closing arguments. Just kind of as orienting myself, I'm looking at RCW 11-130-240, which is the termination of a guardianship, which kind of sets out times where the termination might be proper. And then under 11, under that same statute, under 6, subsection 6, talks about transitional arrangements if the court does end the guardianship. And then it also talks in 11-130-185 about the minor's best interests, and that there's clear and convincing evidence of no parent of the minor willing or able to exercise the parenting functions. And then parenting functions are defined in 2609-004 sub 2. So that's kind of what those standards that I'm looking at. So if I'm off or you want to supplement that, please, I'm all ears. So with that said, I'll hear from the parties for closing argument. Ms. Winkles, you represent the petitioner, so I'll hear from you first, please.
Yes, Your Honor. I represent the petitioner in this case. The petitioner are the paternal grandparents, essentially. Kai Ludwig is the actual biological father of Jaden, and Kelly Crape is his long-term partner. This is the case of a 3-year-old. And essentially this 3-year-old has had kind of a traumatic upbringing. For the first 3 months of her life, she was with her mother. CPS came in and removed the child, and essentially, as the father testified, put the child with him, no questions asked, no parenting classes. It was almost transactional, as the father said. The father had her for about a year. And in that time, the father moved houses repeatedly. He was with his girlfriend, Caitlin Boone, at her mother's house, Melody Boone. And you heard testimony from Melody that she saw incredible neglect. She saw a child that was in the same diaper 5-6 hours. She saw a child eating junk food that didn't have proper food. She saw a child that was essentially ignored so the father could play video games. She also mentioned that the father would smoke marijuana inside, which is what led to him being kicked out. He'd also, as she stated, hoard dirty diapers and the like, and not bathe the child. We then have dad getting kicked out of that place and moving in with his grandmother. Now, there's been testimony on either side here, but my clients have testified that he was kicked out of grandma's house for essentially the same reasons. Grandma did kind of, well, not out and out saying that this is why he was kicked out. She did mention that she wasn't there, it was her husband, and her husband had mentioned kicking him out. She also testified that she apologized for him, essentially from his ADHD, and that's why he wasn't doing the work that she wanted him to do or that she wanted the girlfriend to do. In any event, we've heard a lot of testimony about neglect here. And I think it's really important to remember that this is a child for the first year of her life was essentially deaf. Now, we've heard testimony about singing and listening to music and all of that. The fact is that every normal child by the age of 1 can say a whole host of words. This child was using sign language and could say one word, according to Dad. The fact that nobody did anything about that for 12 months is shocking. And the reason it's shocking is, had my clients not gone in and removed and taken the child and sought medical treatment, we don't know if these issues, deafness, developmental delay, inability to use language, if those would have been permanent. The fact is that my clients came in at the right time and were able to get her care. The child is now developmentally normal. And the only reason that she is meeting milestones is because of my clients. Father did nothing. And I think that's really important, because father didn't have a job. The child was on Apple Care. There was nothing that prevented him from taking this child to the doctor and getting her the care she needed. The state would have paid for the entire thing. Instead, and you've seen this throughout the case, he is more focused on himself. He made a comment that he was looking out for his own safety. He's been looking out for himself throughout the entire thing. He has the ability to give the child medical care now. He doesn't. He has a job. He has the ability to provide funds to the child for her needs. He doesn't. It's not about the child with the dad. It's about himself. And he claims it's his age. He claims that he's learning. The fact is that we're not trying to punish dad here. We're trying to prevent harm to the child. And the child was harmed in dad's care. The child was harmed by her education. The child was harmed by her physical. And the dad claims that he got vaccinations, and he allowed the child to be vaccinated again. Either that, or he lacks credibility. In any event, what we have here is a fundamental failure of a parent to do anything for the needs of the child. You've heard testimony about junk food, and we see his bank records that also is essentially all junk food purchased. All the pictures, minus the one in the park, show dad feeding this child junk food. But more importantly than that, this dad has been alone with the child less than 20 hours, probably in her whole life. This is very concerning, and it shows that the father isn't willing to be the parent. The fact that he can't parent alone, and when the court orders him to parent alone, what does he do? He drives to his friend's house and he leaves the child there. And apparently he claims he didn't go to a marijuana store. Everything in the Google takeout shows that he did. He then goes to his parents' house. Same thing. He pretends to have a job. He doesn't have a job. He gets caught. He gets asked to leave. He claims that he was homeless, yet grandma has always bailed him out. She has bailed him out every single time, and that's what she's doing now. This is more of a case about grandma wanting child than father wanting child. He signed her away. And what he did was he left her for 18 months with not a call. You'll see the text messages where Mr. Ludwig says repeatedly, "Are you going to see your child? Is he going to call?" He doesn't call. He just disappears. And only when grandma drives him to the door in October does he actually try to get his child back. But then instead of thinking of the child, once again, he's thinking of himself. He tries to pull that child out, not knowing a single thing about them. You heard his testimony. Well, what they told me. Oh, his doctors, what they told me. Dad hasn't taken any initiative whatsoever to go to the surgery of the child, to talk to the teachers or the preschool daycare of the child. Has done absolutely nothing. Dad then claims the assault was self-defense. We've seen from dad's own temperament today, and granted, I'm not an easy person sometimes, but we've seen dad's temperament today that he gets flustered and he does react. One can only be concerned about a child being with dad who is going to act out, especially as the child grows a little bit older, as they have language and the like. Child's going to be even more difficult. And how is dad going to react? He does not have the parenting toolbox to effectively parent the child. The fact is dad has no intention of moving out of Michelle Harrington's house. His job is almost 2 hours away each way. He has absolutely no intention. What he wants is for this to go away so that he has no oversight. He's been with this woman for 2 years. They've been living together for almost 9 months. And to think that he's going to move out from there, to move into a place that he was already kicked out of and live in the living room so that his daughter can be there so he can drive 4 hours a day to work at a $16 an hour job is frankly ridiculous. The fact is he has every intention of moving that child into that house. Nothing else states that he won't. Michelle Harrington gives him money every month. Michelle Harrington provides a free place to live. Michelle Harrington, as you heard, essentially teaches him and takes care of him almost as if a mother, almost as if she is his mother rather than his partner. Grandma's house, he's already been kicked out of once. The fact is he's going to be kicked out again because nothing has changed for this man. This is a man who's had a year to go get a domestic violence evaluation, and he hasn't. Now, he's claimed he has no money to do it. That's what he's claimed. Yet we see money going out to marijuana. We see money going out to gambling. We see money going out to Xbox, money going out to fast food, money going out to everything for dad, yet no money going to get his child back. He doesn't go to a DV evaluation. He doesn't do a SUDS evaluation. And while marijuana may be legal, much like alcohol, it can be addictive and it can fundamentally affect and degrade your ability to parent. It just does. Any addiction does that. Dad doesn't do anything. Dad takes one online parenting class that doesn't have a test, yet he says it does. The fact is, it is very unlikely that he took that test, or took that class. The moment he would have entered it, he would have realized that it's how to deal with your ex-spouse and how not to bring your children into it. It's nothing to do with actual parenting tasks. RCW 11.130 looks at the parenting functions. And this is where we find whether or not the parent is not unfit, but whether or not they can actually are able to take care of their child and prevent harm. Maintain a loving, stable, consistent, and nurturing relationship. He delegates all of his parental functions to the women around him. He's done that the entire time. He misses his visits. He shows up late. Sometimes he doesn't show up at all. He drops off the planet for 18 months of a 3-year-old's life. Providing a stable home. All Michelle Harrington has to do is break up with him, kick him out, and they're homeless again. All grandma has to do is the same. And that's because he relies on the kindness of others. Dad relies on the gifts, the benefits of the state when he can, and without the state, private individuals to support his life. That is not the ability to parent. The ability to parent is to be able to rely on yourself to give that same comfort and care to the child. If Mr. Ludwig is getting it from third parties, then the child is essentially getting whatever's left. The father didn't have a relationship for over a year. He can't attend to the daily needs because he's going to be working, according to him, the entire time. And the rest of the time, he's never had to do it. He's absolutely never had to do it. He hasn't provided housing. He doesn't know where he's going to live. Everything is, I'm looking into it, yet no action's been made. There is no change from today than from last year, other than Mr. Ludwig has had a job for 7 months. That's the only change in circumstances here, is he has a job. Absolutely nothing else has changed. He hasn't stopped smoking marijuana. He hasn't moved out from the sex offender's house. He hasn't taken a true parenting class. He hasn't done a DV evaluation. He hasn't done a mental health evaluation. He hasn't done anything. Doesn't have his name on a lease. He's not saving any money. He's spending his money on fun stuff, vapes, weed, all, you name it, video games, the like, but nothing on his child. He can't provide her health care and for her development because frankly, he just doesn't care and doesn't understand it and has never forced himself to learn. This is a man who's very well spoken. You heard his testimony. He is quick. He is very quick to come up with an excuse or come up with a reason, come up with these. He's quick. If he wanted to learn about what she needed, he could. He has an unmistakable lack of effort and commitment to this. He is here, but he is not committed. If he were committed, he would actually do more than try, he would do. So, Your Honor, my clients are asking for a proof of stability, a lease in his name where there's no sex offenders, where the child has her own room, a job that is within an actual distance from that place of residence, close to that, a job for a year. This is a man who's bounced around. He worked at Foster Farms. He gave testimony, apparently made it sound like he worked there for years. He worked there for a week and a half. A DV evaluation, absolutely. a mental health evaluation, and a SEDS evaluation. We're asking for all those with collateral contacts. Again, my clients are trying their best to give him visitation, to make parenting time up when he just doesn't show up or doesn't call. But the fact is this child needs to have stability. The first 3 years of her life were essentially without noise. They were without noise. And this was a child that couldn't hear, that was just getting moved about all over the place. Inconsistent people, inconsistent houses, just inconsistent stability. So, Your Honor, we'd ask that you protect her from the sex offender, because that's where dad is really going to be headed. Otherwise, he would have made some sort of move to grandma's already, and he hasn't, because he has no intention of doing that. We ask that you maintain the minor guardianship, that my clients be appointed full minor guardians, that dad continue on the visitation schedule that he's on, maybe with a review in 3 months to look at overnights. They don't want to stop him from doing that. He's absolutely not ready yet, as he's not even been with the child during the day alone for more than 2 hours, while a safety is sitting in the car, essentially girlfriend or grandma. They're never far away to help him. They pay for the food, they pay for the hotel. Dad needs to learn to do it on his own. He needs to go to that 12-week parenting course in Chehalis that he's talking about, not just say he's going to do it. He needs to actually do it and learn the toolkit necessary for this child to thrive. Thank you.
Thank you, Ms. Winkles. Mr. Adagnostic, closing on behalf of the respondent.
Yes, Your Honor. Thank you, Your Honor. I guess I want to start from the law. As part of this case, I reviewed Troxel versus Granville. I'm not sure if Your Honor has reviewed it lately. It's just a beautiful case. There's a paragraph in Troxel that says, the liberty interests at issue in this case, the interest of parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interests recognized by this court. More than 75 years ago in Meyer versus Nebraska, we held that the liberty protected by the Due Process Clause includes the rights of parents to establish a home and bring up children and to control the education of their own. And then that paragraph goes on, but it ends. It is cardinal with us that the custody, care, and nurture of the child reside first in the parents, whose primary function and freedom include preparation for obligations the state can neither supply nor hinder. And that was the Troxel versus Granville case. From there, we go to RCW 11-130-185, the new statute. It indicates that a person becomes a guardian for a minor only on appointment by the court. And then there's some elements in it. The last one is, there is clear and convincing evidence that no parent of the minor is willing or able to exercise parenting functions as defined in RCW 260904. And I put it to you, my client is willing and able to provide parenting functions. When you look at RCW 260904, it defines parenting functions, maintain a loving, stable, consistent, and nurturing relationship with the child. You saw the pictures and you heard the testimony. Jay Lynn loves her dad, and he loves Jane Lynn, and they have a stable, consistent, and nurturing relationship. I guess we can argue about consistency, but that's because of visitation and him traveling from relatively central Oregon up here on weekends, and him having a job and not potentially being able to do the phone calls when they're ordered, and trying to get other times with the petitioners, that was problematic. But for the most part, he has been consistent. He has been coming up here going on a year now to see his daughter. They have a fantastic nurturing relationship. The statute goes on, attending to daily needs. Well, he can't attend to daily needs because he doesn't have, he's been trying to get cut. But when he's up here, they criticize him because he's up here, and sometimes he could get a room, if Michelle was with him, but if not, he would have to come up here, visit Jalen, drop her off at 6 o'clock, drive back to Central Oregon, drive back up the next morning and get to visit her for a few hours during the day. So he's done the best he can. And if, they're criticizing, well, you're not feeding her. And so we showed you pictures of him feeding her, and but that's not good enough because now it's junk food. You're feeding her at Burger King. So nothing my guy can do can satisfy them with regards to the daily needs of the child, such as feeding, clothing, physical care, grooming, supervision, health care, daycare. He has done all of that in very small chunks because that's what he has been given. And we've been repeatedly asking to expand that so that we could transition Jalen back to her father. But here we are. So now we're at trial and we're asking the court just transfer her, transfer her, and she will move to Toledo, and my client will live in Toledo until he gets a place closer to where he's currently working. And, that may take a month or so for him to do that, but he's applying for low-income housing and various other, and Salem's a lot bigger than Silverton, so he may have more success there. But he can't even start that process until he has Jalen in his custody. I mean, he can start the process in the sense of looking and seeing what's out there, which he's done, but actually applying for benefits for people with children, he can't do that until he has the child. He's already got plans for adequate education. She'll go to daycare while he's at work, and then from there preschool and on. It just goes on and on. My client has the ability and can provide all of the parenting functions as defined in RCW 2609004. He just hasn't been given the opportunity due to what has occurred in this case. Although he has, repeatedly asked for that opportunity to care for his daughter on a full-time basis. So here we are. They bring up, a lot of issues that just aren't relevant. So there was an allegation, basically, that he was neglecting Jalen's medical care. And you heard testimony from the daycare provider about, about the time when children get tubes in their ears, which was about the time that they discovered Jalen needed to have tubes in her ears, and she got the tubes and she's fine. But that was a time after this incident where they say my client assaulted Kelly Crape, and it was just this fiasco, but a restraining order was put in place. So he had no ability, no contact with Jalen, and he testified to you, and we pointed out the document, the restraining order prevented him from having contact through third parties, and he just believed that if he contacted Kelly at any point, he would go to jail. She believed that too. She said that if he had violated that order, she would have called the police. And he knew that, so they didn't find out that the order was dropped until a month or so after it was dropped. And that's when my client a year ago in October contacted him saying, I want to pick up my daughter. And they basically manipulated my client, said, no, you can't just pick her up. Why don't you leave her here? Why don't we do a transition thing? And instead of doing a transition thing, they file this action and prevent him from having reasonable contact with his daughter, other than him having to come up here, which he has done to the best of his ability. There is no evidence that, counsel indicated that the child was harmed in dad's care. She was not harmed in dad's care. They did discover after he was removed, the restraining order removed him from the home and allowing him contact, that she needed tubes in her ears, and that was taken care of. But beyond that, there's no harm that's ever happened to Jalen and my client's care. There's just kind of vague allegations that, he wants custody for his grandma. He wants custody for Michelle. He doesn't want custody for himself. It's just none of that's true. He is Jalen's biological father. You saw the pictures. They have a close, loving relationship, despite the fact that he gets very, very limited time with her. She wants to be with her dad, and he wants her in his care. And he has, we've repeatedly said in answers to interrogatories and during court hearings that he's going to live in Toledo. She has a bed there. You saw the pictures. Everything's appropriate. He lived there when he was a kid with the petitioner Kai Ludwig. This home is appropriate. That's only for a very short period of time until he gets housing in Salem or Silverton, and gets settled closer to his employment. In the meantime, he'll commute the 90 miles back and forth and until that happens. But from his point of view, it's going to be a short period of time. I disagree with counsel's indication that my client, he did get frustrated, but I don't think, saying, well, he gets frustrated and he reacts and it's all negative. I think you got to measure his demeanor during this trial. He's under a lot of stress, and despite that being under a lot of stress, he testified for hours today, and they had every opportunity to present evidence where he is a violent, mean person. They didn't come up with any of that. His testimony regarding the incident and the pictures of the bruises and injuries to him with regards to what happened that ended up causing a police investigation to be conducted. He was attacked by several people there at the home, and he left. From there, the criminal justice system had charged him, but those were ultimately dismissed. But in the interim, there was a restraining order in place, and he wasn't going to violate that, and he wasn't going to go to jail. He respects the orders of the court, and that's the demeanor that came through to me. They no matter how many times we say it that he's not going to move into Michelle Harrington's house, they continue to say that he is. Without any proof. But there's a simple solution to that, any court order that you make indicates that Jalen is not to be in that home. We'll comply with that. They can apparently, with cell phone technology now, wherever you go, shows up on these Google searches, and so, they can keep track of whether he's got Jalen at Michelle Harrington's house. It's just not going to happen. It's not going to happen, but the court can enter whatever orders. The issue is they don't want him to have custody of his daughter based on an allegation, just an allegation. We think you're going to commit murder, so you shouldn't have custody. We think you're going to go to Michelle Harrington's house, so you shouldn't have custody. It's the same thing. There's no basis for that. And he has a close, loving relationship with his daughter that needs to be protected. And they're defeating that or denying that at this time based on vague allegations. They have made an allegation that initially they said that he shouldn't have custody of his daughter until He's been at the same job for 6 months. I think that's in some of the pleadings, and might have been in their recommendations. Now it's a year, and so they're just upping it because he's been at a job for 6 months. So that's got to come off the list or be expanded. That's the way they think. They want a mental health evaluation. The court didn't order that on a temporary basis. My client nevertheless volunteered and said, if you want me to have a mental evaluation, I'll conduct one with input from you guys. You guys just have to pay for it. They never made arrangements to do that. And the same thing with substance abuse. The court has heard these allegations. The court never said he did supply a UA. I think the court asked that, and he did that. But at no point did they want to make arrangements and pay for a substance abuse evaluation with input from them. He would have done that. He said that in declaration, he would have done that. But at this point, there's no basis for there's no basis for a mental evaluation. He doesn't have mental health issues, at least none that have been demonstrated here. And substance abuse, he indicates that he smokes pot at night so that he can sleep. And other than that, he's been showing up for work every day early in the morning for the last 6-7 months. And there's just no basis, but nonetheless, he would have done it had the petitioners paid for that if that's what they wanted. So here we are. You've gotten all the evidence. You've gotten tons of evidence, Your Honor. What needs to happen here is this guardianship needs to be dismissed, and Jaylen needs to be returned to my client. If the court wants to put provisions in there that Jaylen not be at Michelle Harrington's, my client has no issues with that because she's not going to be at Michelle Harrington's or ever around her son. Not going to, both parties testified that they're not going to endanger Jaylen nor Michelle Harrington's son. My client get custody. She will immediately move into Teresa Ludwig's house in Toledo, Oregon. He will start looking for housing closer to his employment. And that will be the benefit for both him and Jaylen. But we need to conclude this case. There's just no basis for granting a guardianship to the petitioners.
Thank you, Mr. Anagnostiu. Rebuttal closing, Ms. Winkles.
Yes, Your Honor. Mr. Anagnostiu brought up Troxel, but what we need to do is think about what the facts of Troxel were. And Troxel was a case of grandparent rights. And the parents in that case were not deemed unfit, which was the standard at the time, and weren't deemed to have any issues. It was grandparents trying to seek rights. And the court was talking about it and not looking at the child. It was because there wasn't an issue with the child. It was looking securely and pointedly at the parents' rights. This is a different kind of case, which is how minor guardianships have evolved over time. This is looking at the child, and it's looking at preventing a harm to the child, which actually supersedes somebody's constitutional rights. The court here has a mandate that is to essentially protect the child and to not just do what is in the child's best interest, but to stop a harm from coming if the parent is the one who is going to not protect the child from that harm. And here, what we have is we have significant harm. We have a child that God only knows what her developmental delay would have been had she remained in the care of dad. This is a little girl that for 10 months had no hearing. She had no way of speaking, no way of getting her, no way of being understood. She was essentially left on her own, which is what everybody testified. Dad ignored child. Had it not been for my clients, this child most likely would have been so delayed in school that it wouldn't be the child that everybody loves, that's talkative and sweet today. The fact is that dad had a duty of care to this child to make sure that the child was getting adequate medical care, and he didn't. He just didn't. He allowed, according to him again, allowed the child to be vaccinated twice. What is the harm? The harm is that this child had learning difficulties with dad. The child was deaf with dad. That is the harm. And that harm will come again because dad is going to be at work Monday through Friday, and it's about dad. It's not about the child. It's about I'm going to work. And the fact is who's going to take this child to the doctor? Dad didn't even go and visit the child when the child had surgery. Dad didn't go and call the daycare, hospital, or anything to find out anything about this child. The fact is dad is using the restraining order, the no contact order, as his reason. It's an excuse, which is what we find here. But the restraining order only stopped him from going to Kelly. It didn't stop him from doing anything else. And we know it didn't because he talked to his sister. He met up with his dad. His dad texted him, come see the child. He didn't. He could have. He called the police to ask if he could go up there in October. Why didn't he do it earlier? Why didn't he find out what he could do? He never petitioned the court. He never did anything because frankly, he just didn't care. He left this child for 18 months. Not a whisper, not a thought. The fact that he's able to bond with her now is wonderful. But where was he for 18 months? He was off living for himself is what he was doing. And we see that still going on today. We see him, they say, do the DV, pay for the DV, pay for the SUDS, pay for the mental health, pay for the parenting class. Dad just needs to stop smoking weed, stop spending $40, $50 a month on vapes, stop, buying fast food every single night, and stop having fun with his money and do what other parents do and put their children first. But he can't do that. It's about him. It's about my safety, he says. It's about him. He is incapable of doing the parenting functions. They found that when they put the emergency order in place, they found that he was incapable. He was incapable then, so what has changed to now? Absolutely nothing. Dad says, I don't need any of this. Dad says, well, I'm looking into it. Why didn't he do it? If he really wanted, if he really had the willingness to parent this child, he would have done some sort of effort that took him out of his comfort zone. He would have found his own place to live. He would have found a better job. He would have gotten the evaluations, but dad doesn't do that. Dad lets everybody else do it for him. To place a child in the care of a man who has never been alone with the child minus 2 hours when somebody was in the car, who didn't change a diaper, who didn't feed the child properly, who didn't bathe the child, because we've had testimony of all of that, who was in his room and the child walked out and went somewhere else. He didn't know where the child was. He was in that room, according to testimony, for hours. That child at 3 years old could have been in the street by then. Dad didn't care. He didn't have a willingness, and he definitely doesn't have the ability, because the ability comes through hard work, and it comes from sometimes dad says, I'm young, great. Go to the parenting class. Great. Do the evaluations, go to the treatment, do what you need to do. And dad saying he's not violent, there was a protection order. There was another petition for a protection order, and Melody Boone testified that he was violent to his girlfriend. We've also heard testimony from his own father that said he had an anger problem growing up. He's always had an anger problem. We've heard about his issues as a child, shoplifting, some strange sexual behavior, some strange hygiene issues. We've heard of all of that. Running away to grandma's house. Grandma's going to protect him, but grandma's going to kick him out. The fact is, until dad can take care of himself, even the minimal, a place to live, ability to, and recognition that the money doesn't go to fun stuff. The money goes to the basic tenets of survival. When dad understands those things, when he has that toolkit, then he can perform the parenting functions. But right now, how can he? It's all he has to do is make somebody mad, and he has no place to live. He has no stability. All he has to do is he has no savings. He can't, he essentially can't pay for anything himself because all of his money is already spent. This is a man who thought it was okay to drive without insurance in the car with the child. And we've heard from the guardian ad litem, she was concerned that this child was going to Michelle's house when it shouldn't have been. This is a man who brings him to another friend's house that he smokes weed with, and the Google takeout shows he leaves child there. He goes and buys weed. He claims it's a different store. It's very specific, and he comes back. The fact is dad's always about dad. And until dad changes that, this child is in significant risk of harm. She is at risk of harm of being with a sex offender. She is at, because if grandma kicks him out, where else is he going to go? She's at significant risk for more developmental delays. She's at significant risk of letting her education fall back, letting all of these things, because dad's going to wake this child up at 5 a.m. A child who is not used to that because dad wants it. Not, I'm going to go find another job. $16 an hour, McDonald's pays 19. Not, I'm going to go look for another job to make sure I can parent, but I'm going to wake the child up at 5. That's just what's going to happen. It's about me. It's not about the kid. This little girl has suffered enough. She's in a good place. She's been stable there. Any transition to dad, more than very minuscule, is really going to affect this child. This child knows stable Kelly, knows stable Kai. You've read the home report that's in there. This is a family that already has an adopted child that really takes care of these people. Dad claims that they were abusive. Dad claims all these things. Yet dad left the child in their care. So either he was negligent and leaving this child with them and not doing anything for 18 months, or frankly, it's false. This child is doing really, really well. And to put her in a place where this guy doesn't even know where he's going to live tomorrow, his job is so far away from where he's going to live. He's going to try. He's going to try. And maybe dad will Google parenting functions. Maybe dad will Google how to do this. But will dad actually do it? It's a whole other question. Until he can show some sort of willingness to get out of his comfort zone and actually perform the parenting functions that are in RCW 26, this little girl is at significant risk for dad just going in and playing video games and her walking right out the door. So we'd ask, Your Honor, to keep the minor guardianship. There's nothing, putting a court order where he can't go to Michelle's house will not work. There was a court order that stated he had to be alone with the child for several hours every visitation, and he didn't do it. He doesn't do it because as long as he's not watched, he can't do it. My clients can't police him. They can't put a PI on him. They've spent all of their entire retirement on this case. There's no ability to police him. That is what a minor guardianship does, is it puts a protective insulator around the child so the court can continually have intervention until that parent is now willing and, more importantly, able to give the child the basic needs of parenting. So, Your Honor, I'd ask that that they be appointed full minor guardians, that dad have visitation as it is now, with a review in several months to see if dad's doing any of these things he says he's going to actually see if he does something. It's unlikely and unfortunate, but without doing anything proactive, change usually doesn't just appear de novo from the earth. Thank you.
Okay. Thank you, Ms. Winkles. Okay, so I'm not going to give you a decision right now. I want to, as we all know, this is the part 2 of the trial. And while I reviewed the notes from last time, I want to review them in conjunction with today's testimony and the exhibits, which are not a few. So I'm looking at my calendar for the remainder of this week. Let me just check one item. I'm looking at potential slot on Friday morning, or pardon me, yeah, Friday morning. I think Friday's going to work, but I just want to make sure that it's going to work before I lock it in. What I'd like to do, and if the parties are amenable to this, I'd like to just run down to my court scheduler to make sure that the morning of Friday, the 29th of September, is a possibility. So before I make the trek down to the court scheduler's room, can the parties let me know what your schedule looks like on Friday, the 29th?
Included trial yesterday. So trial is in front of Judge Evans, and he's going to make a ruling on Friday. So that's where that case is.
So we'd ask, so we'd ask to extend the order. I believe it actually it ends today. So we'd ask for an extension of the emergency minor just until that decision comes out on Friday.
Okay. And that's what I did see, was that he had already set a date for his ruling. So let me just get to the last order. Okay. So our last order. I thought said through the hearing, but maybe it didn't. Give me just a second. The duration of our last order went through the quote, until a final hearing is held, end quote. Since that hearing's been held, but you don't have a ruling, do you folks want me to re-up it through September 29th, or are you comfortable with the language that's in the last order?
I'd like it re-up, just given the issues at hand. I can draft that though, since I have the original one. I can, just so Your Honor doesn't have any more work to do, I can just change the date on it and send it up.
Okay.
Yeah, and I guess my position was we don't need another order if that's what the order reflects, because the hearing hasn't been concluded. So, but that's fine if council wants to draft another order.
Okay, let's just do that out of abundance of caution. I know different people could read that wording different. So we'll go ahead and Ms. Winkles, go ahead and draft that, circulate it. And then if you email it over to Sylvia, I will get it signed.
So we're here today after 2 days of trial and presentation of testimony and evidence. And we're here for the court's oral ruling and discussion of the case and the evidence that's been presented. So in preparation for this, I obviously sat through the testimony that was presented on both days. And I then went back and reviewed all of my notes from all the days of testimony. And again, I've looked at the statutory requirements under RCW 11-130-240, which is the termination of guardianship. And then 11-130-185, which talks about the minor's best interest and clear and convincing evidence of the parenting functions. And then 2609-004 or 004 is the parenting functions. Then also I looked at 11-130-240 sub 6, which talks about transitional arrangements. So I'll just jump right in and just kind of share my thoughts. So there was a lot of, I guess the story starts when Jalen was born, had been born about 3 months to the birth mother. The birth mother was really struggling, and CPS in Oregon contacted the father, Mr. Ludwig, and said, hey, can you take the child? And he did. He took the child. And from there, there's a lot of information that was presented about his lifestyle and his abilities to care for the little baby, and women that were involved in his life, either girlfriends or grandmothers, mothers, other adult females that provided some help and stability to him. So a lot of the focus here is on the parenting functions of whether Mr. Ludwig has shown, Jaden Ludwig has shown that there's clear and convincing evidence that he is willing and able to exercise the parenting functions as defined in statute. What I think is interesting when looking at that statute 2609-004, the key language that jumps out at me is, says parenting functions means those aspects of the parent-child relationship in which, and this is kind of a key point, the parent makes decisions and performs functions necessary for the care and growth of the child. I'll kind of give you kind of my summary conclusion related to that. My sense with Mr. Jaden Ludwig is that I think Ms. Farr summed it up nicely when she said that he has kind of a go with the flow type attitude in life. And what I saw in the testimony presented was that there was a pattern of abdicating responsibility to others for the care of the child. That's not always, I guess maybe abdicating is maybe a strong word, but sometimes we have to defer parenting responsibilities to others or ask them to help out. That's normal. As they say, it takes a community to raise a child. Here, what I saw with Mr. Jaden Ludwig was more of he wasn't leaning in. He wasn't leaning into the parenting function. There was maybe a sense of helplessness, self-imposed helplessness, that he felt that he couldn't live up to that, or there were just these strong-willed other people and women that stepped up and kind of took charge, and he allowed them to do so. And I think I think he's learned a lot about parenting since those early days, and I don't think he knew a lot at the get-go. And I think over time he's learned quite a bit, and I think he still has a long ways to go. So in my mind, there continues to be clear and convincing evidence that Jaden Ludwig is not able to make decisions and perform functions that are necessary for the care and growth of Jalen. And I'll go into some of the specifics as were discussed in the trial. So I think being a parent, you don't necessarily always need to be, quote unquote, a leader in the well-being of your child, but you certainly need to take a kind of a strong hand and be the captain of the ship, if you will. I got the sense that he was more of a passenger than the captain. The child here needs somebody who can make decisions and perform functions that will be necessary for her growth. And I'm not sure at this point if he has that capacity to make those decisions and perform those functions. Financial contribution to the child. So since the child has been in the care of Kai and Kelly Ludwig, there's been a nominal financial contribution. There was the EBT card at some point. The graduation party talked about how he had his EBT card in his wallet, and then when he got it back, it wasn't there. He did indicate that when he was living with Kai and Kelly, he did contribute by providing the EBT card at times. The EBT card wasn't used solely by Kai and Kelly, but Jaden also used it for his use purposes. So since that time, Jaden has been working for approximately 7 months at what seems like a good fit job for him. He makes about $16 an hour. And during that time frame, he has provided zero financial contribution for the daily care and care of little Jalen. And I think that's important to note that there was no testimony that he sent up $5, that he sent $20 up, or he sent a box of diapers, had it delivered. There was information that he, supplied a few cute shirts and some other sporadic supplies, but nothing on the regular. And I think that's significant because what we know, he's not paying rent currently. He's paying utilities at Michelle's house, but his financial obligations are nominal or minimal. I won't say nominal, but they're minimal. So there is certainly means by which he could supply financial contributions, but he's chosen not to do so. I think sounds like marijuana use has been something that Jaden has joined in for a significant period of time. Sounds like it was during high school and it's continued. And I think, and I don't know, but I think the marijuana use may have contributed to kind of his backseat approach to parenting. Sometimes I noted there wasn't a great sense of urgency with parenting tasks or the like, and that marijuana use may have been a contributor to that, sapping him from motivation. There's also information as far as there's the issue with the graduation party and the violence that occurred there, and this happened just 2 weeks after Jaden left the home of his father in Kelly's home and went to grandma's house. He came up for the graduation party and there was a scuffle and it didn't turn out well. And so there was that issue. There was some question about this other domestic violence, whether that was really him or not. It's kind of up in the air in my mind. I don't think that was conclusively proven that was him. So there is some concern for his emotional regulation in pressured situations, and we can point to the graduation issue. And I think we can also look at, I don't think the time that he was living with Kai and Kelly was not necessarily a pleasant period of time. I think there was a lot of pressures on him, and I don't think he maybe reacted to the best way that he could have as far as stepping up to the plate. I think he delegated a lot and stepped aside when people decided they were going to take care of the baby. And I think there was significant information, even when you take into account people's biases and the like, that during those early years of the baby and the changing the diapers, he was pretty focused on himself and hadn't really gotten into the groove of being a parent and what it means to be a parent. And so it was easy for him to not pay as a close attention to the child as maybe he should have, where there were some supervisory issues and also probably playing video games maybe more than he should have been, rather than being involved and focused on the child. There's the issue of housing instability that was brought forward during the trial. There is a past history of instability and some frequent moves that Jaden has worked through. At this point in his life, he doesn't necessarily control his own destiny. And not to say that, somebody that doesn't have their own home, doesn't have their own lease, that's going to prevent them from caring for a child. I don't think it necessarily does that, but when there's been a pattern of breakups and moving to his mom's house, moving to Melody Boone's house up in Spokane, not being able to stay there, not being able to stay in Kai and Kelly's home and abiding by different rules and getting along. I think that's of concern. And also that at any point, if you were to move to Grandma Ludwig's home or continue to live in Miss Harrington's home, apparently at Grandma's house, he had been exited there. It wasn't quite clear to me why that happened. Sounds like maybe Grandpa was maybe more of a driving force than Grandma was in his exit, but he had been exited from that at one period in the past. So at this point, the connection between Jaden and Jalen occurred in October of last year when they found out that the no contact order had been dropped. Since that time, there have been visits, and there's been kind of this cobbled together plan that Jaden's looking at moving to Grandma's house with Jalen, and then commuting the 1.5 to 2 hour drive to Silverton and then drive back. So that's there. And then he talked in his testimony about, housing costs, $200,000, $300,000. He says that's money that a 23-year-old doesn't have. I get it. Rents are really, really high. And yet at the same time, there's been this long period of time, a year almost, for him to find housing, to save up money for housing. And the evidence shows that he hasn't done that. He hasn't saved money. There's nothing in the bank. And I recognize that he's spending a lot of money for these trips up for the visits. It's not cheap. Gas is expensive. There's housing or sometimes the hotel costs. There's a lot of money going out the door. And yet there's not a showing of I've saved $100. I'm saving $10 a week or something towards for a down payment on a rent. That goes to making decisions and performing parenting functions in preparation for having a child with him. He has identified a daycare provider in the Toledo area where Grandma lives. I think he said it was Head Start. And he's indicated that his physician is probably still in Toledo. He's indicated that he doesn't have necessarily the option to sign up a doctor or get the child enrolled or registered with a physician because he doesn't have custody. Nonetheless, I got the sense that he wasn't taking steps forward to prepare a nice nest or a landing spot for Jalen. The issue of the relationship that he has with his child, there's no doubt that Jaden loves his little girl and his little girl loves him. That's clear. They have a really good bond, and I think it'll only get better over time. The visits have been much more consistent over the past year, and yet I think there's some telltale signs of weakness in the relationship. There was testimony that the month of September that the visits were going to be canceled because he had other things happening. There was the 18-month period without seeing the child, which was a big deal. And I'll be, to be honest, that no contact order to the uninitiated, when it says no communication third parties, it wasn't written in a full sentence. And so was there a degree of uncertainty there? Yeah, I think there was. Did Jaden have opportunity to maybe clarify that? I think he did, because he even said that he had opportunity to clarify something with the authorities related to the graduation assault. He didn't do that. And I recognize his hesitation because I'm positive Kelly would have called the police if he would have contacted her, and that would have been right and proper. But there wasn't, I didn't feel him leaning in, having this strong desire to connect and be with his child and nurture and teach and be with his child. There was no evidence that he had called and specifically asked his sister Holly or his dad. And I recognize the relationships are strained and they may not be the best relationships, but there was no connection that he had contacted them to say, hey, I'd really like to see my girl. And there was clear that you could do so without involving Kelly. His fear, it seems, is that if he called one of those individuals, that information would get back to Kelly and he might get himself in a boat full of hot water. And I can recognize where that fear is coming from. And yet it seems that he was paralyzed by that fear more than his desire to see his child. So that's of concern. The visits, I'm glad that he's been pretty darn consistent with the visits. He's been habitually tardy to them. Pretty much most of the visits he's been tardy, the vast majority of them. And then notwithstanding the need to the court order to have one-on-one time with the child during those visits, there's regularly and continually been other people that have been there at the visits. I got the sense from Grandma Ludwig is that she's kind of a step in and let's get stuff done type of person. One may even use the word enabler with Jaden. I think Kelly also is a strong woman that will jump right in and take care of the child. And so I think Jaden may have been conditioned to be somewhat passive in his parenting just because of the presence of strong women and that they would fill in when he did not. And I think that's a pattern that's been continuated and perpetuated. There was the issue related to the hearing. And I tend to agree that that's not a terribly uncommon issue as far as tubes. I think that happens with some, it's common, it's not rare. And that I think father was a very young father. He stressed that a lot in his testimony. He said, hey, I'm just young, I'm a young father. And I don't disagree with that. And yet by the age of 1, the child had a vocabulary of basically one word, dada, and knew some sign language. Obviously a bright girl, little Jalen, but the hearing issue was prohibiting her from hearing words and mimicking them. So if left on his own, I don't know if he would have rapidly discovered that. I think Kelly was in a good position to spot that because she's around kids with frequency because of her daycare job. But without that, I think there would have been possibly some long-term impediments and obstacles imposed upon Jalen because he wasn't just up to speed with that. And, I think, in his defense, nobody comes with the parenting manual all spelled out of what to do at certain levels. But again, it's that kind of that passive approach to parenting that he's going with the flow. He's not making decisions and looking kind of ahead of what needs to happen and how he can care for his child. There was concern for vaccinations, of double vaccinations, of just not being tuned in and going the extra mile to see exactly what is the status of past vaccinations. And there was some indication that the child received double vaccinations. As far as one of the parenting functions is basically exercising appropriate judgment. So I think it's a fair area to describe his plan of what his plan was. His plan was to have the child stay with him at grandmother's house in Toledo, Oregon, and he would drive the 1.5 or 2 hour drive to work in Silverton. He'd finish his shift at 3:30 or so and come back and be home by 5:30. I think given his track record as far as his work history and his kind of passive approach to life, I think it's an untenable, non-sustainable plan, especially when you take into account the high cost of commuting and the tightness of his funds. I think this testimony bore out that it would be roughly $800 a month in commuting costs, $15 to $20 per day of commuting. That's a lot. And also the fact that he's relying upon the kindness of others for housing that could be revoked at any point in time, and has been in the past, where he's kind of worn out his welcome, hasn't followed the rules. Sounds like his relationship with Michelle Harrington is pretty good. They've been together about 2 years, but at this point they're not married, and the age difference is significant between the two. That's not always a barrier, but it's interesting though, because I think in a way it's showing an attachment of Jaden to a strong woman in caring for his needs. I think there's also some judgment issues shown in the father's credibility related to saying he's going to work, but then not going to work at the temp agency on a variety of situations. There was a sense that he was kind of hiding things, and that led to a loss of trust. There was also the fact that Ms. Harrington has her son living with them at the Silverton address where dad resides, and that information was simply not shared with anybody until the spring of 2023. And again, he's been in a relationship with her for roughly 2 years. In addition, I think the judgment issues are related to the GAL of Ms. Farr, where she indicated that on multiple occasions, please keep me updated with any changes, any new information, anything that affects the welfare and guardianship of little Jalen. She reached out to him on numerous occasions with no response. And again, there was no disclosure of what would seem to be a very salient and important piece of information related to Tyler. I think it was the young man's name, Miss Harrington's son. As far as the financial, I talked about this a little bit before, but I want to just touch on it a little bit more, is that the caregivers here, Kai and Kelly, have been footing the bill and the cost for the child, and that the day-to-day needs, the father has not contributed to that. And I think I mentioned, maybe hadn't sent $10, hadn't sent $25, and yet he's an active marijuana user. Marijuana is not a necessity. Food and clothing for a child is a necessity. And I think that ties into his judgment and making appropriate decisions and caretaking decisions for the child. Education is one of the parenting functions that's also discussed in the statute. I get the sense that he's not very tightly attuned to the child's developmental needs and the daughter's educational needs, and I think that's borne out through the issue with the hearing. There was evidence that he is reading to his daughter, and that's much welcomed and appreciated, and he's to be commended for that. There was no indication that during the time frame when he was not in communication with or direct contact with the child, that he ever reached out to the daycare center. And I recognize that's a little dicey because that's where Kelly worked, but there was not even an attempt to learn where the child's at, what's the child learning, are there any issues or concerns related to daycare, because that happens sometimes. Little kids can get aggressive with other little kids, and it may not be the best environment for the child. And so there's not a lot of information of him inquiring and trying to find out what he could do to help support what Jaylin is learning at daycare. And I think that's, even to this day, even with the dropping of the no contact order, I didn't hear any information that he's reaching out to the daycare center and finding out, hey, what lessons are you having this week? I'm going to have a visit with my daughter this weekend. I'd like to know what's happening there, and so I can aid and support in her education and what she's learning. So a termination of a guardianship occurs in this scenario where the court finds the original basis that there's no parent willing or able to exercise parenting is absent. I find that it's not absent; it still exists. That there is a parent willing. I think he's willing, but I think at this point there are some impediments that can be overcome and should be overcome for him to properly exercise appropriate parenting functions. If that would, so there's not going to be a termination of the guardianship at this point, because I think I find that it would be harmful to Jaylin if that were to occur, and it's not in the minor's best interest for that guardianship to end at this time. Now, will it happen in the future? I think it will, and I hope it will. But I think at this point that clear and convincing evidence is not established that he's willing and able to exercise those parenting functions based on those factors that I addressed in my comments. Lastly, I'm denying the motion to reconsider, or the motion for revision that was previously put forward by the parties based on my information of that revision. So I just wanted to make sure that was clear also. So that's the court's ruling, and I'll entertain if the parties have any questions or clarifications.
My only question, Your Honor, is visitation going forward.
Yeah, obviously that should continue. There was a request for continuation as is, and I think even one party suggested maybe moving to alternating weekends for a variety of reasons, one of which may be just the ability to save a little money so the housing could be obtained in the future. I'm open to hearing from the parties related to what you feel visitation should look like. So I'll just turn the time to each party. Ms. Winkles, you're the petitioner, so I'll hear from you first, and then hear from the respondent's attorney, Mr. Anacostia.
Yes, Your Honor. My clients would ask for it to be every other weekend, given the fact that they're trying to, they have other children as well. And what it means when dad's there every single weekend is they can't do anything as a group. So they are essentially waiting for dad to get there. Sometimes he's hours late. Their other children suffer because their other children have extracurricular activities. Their other children want to do things with their parents and they're unable to do so. It would make more sense because dad's often late. Dad has trouble with the money to do maybe even a little bit longer of a visitation on the Saturday and Sunday every other week. That would allow dad to have more quality time, and it would be cheaper for him. He'd only have to pay for one hotel should he decide to stay there. And hopefully the relationship can grow after this, and maybe they can all have dinner together or something like that in the future. But for right now, it's incredibly stressful, because what it means is one parent in the household is taking the adopted or biological children, and the other parent is taking this child and sitting in a car and waiting. So logistically, it's impossible. Additionally, my apologies, Mike.
It's okay. It's okay. It's not that bad.
He's 16 years old and he's blind and he's deaf. So we would also ask that they have a set place that they're going to meet, and they have a set time. And after that set time, for example, right now, he could be an hour late. My clients have to sit there and wait. So we'd ask for a set time where if he doesn't show up, be it 15 minutes late, be it 20 minutes late, that my client can go. And I understand dad says there's traffic and dad says there's these things, but the fact is that anybody that commutes for a job has to factor that in. And sometimes they get there early, but they make sure they always get there on time. And so that's what we're asking.
Thank you, Mr. Adamowski.
Yes, Your Honor. My client needs to have, we'd request every weekend to continue. And we would like an expansion of his visitation. If the court's not going to return his daughter to him, it should be every weekend and from Friday through Sunday. And he should be allowed to pick up his daughter and go to his grandmother's house in Oregon. He gets off, as you indicated, 3:00 on Friday. He could be here in Longview by 4:30 or so. It's an hour and a half drive. He gets his daughter for the entire weekend and comes back and meets them on Sunday and returns Jaylyn. That way they could have their whole weekend to do whatever they want to do with their other family members. The significant issue for my client has been having to come up, get to see his daughter, have to leave, either get a motel room or drive back to Silverton where he's staying until he gets his daughter, and then have to get up in Sunday and come back up and then go back home. I mean, that's 4 trips on a weekend. We could reduce this substantially and give the petitioners, their entire weekend to do whatever they want with their family. Simple solution. My client gets Friday through Sunday until we go forward with, at some point he needs his daughter returned to him, but I understand what the court's looking at this particular time. And that's what we would request is every weekend from Friday through Sunday, overnights. You can put restrictions on it not to occur in Silverton, and they won't. He would spend the weekend with his daughter in Toledo, Oregon, at his grandmother's house. And he'd be doing all the care for Jaylyn.
Thank you. Ms. Farr, do you have any input?
Yes, Your Honor. Thank you. I wasn't planning on any input, but what I would say is that we do have an established pattern that Mr. Ludwig has not been providing one-on-one care for the child. And I think until he actually can show a pattern that he's able to care for that child one-on-one without the help of other women or other people, that there shouldn't be overnights. I don't think the child should be required to travel to and from Silverwood to Toledo, Oregon every weekend or every other weekend. I think father needs to figure out how to make accommodations that are in the best interest of the child, not in the best interest of himself or his grandparents or other people. And until we have that pattern established that father can provide for that child by himself during the day, there shouldn't be any overnights. I also agree with Ms. Winkles that it should be every other weekend.
Let me ask a quick question. I forget, but currently the visits on every weekend, they're unsupervised. Is that accurate?
Yes.
Okay. And So tell me your hesitation as far as with overnights.
That he hasn't provided the care for the child during the daytime hours on his own. It's always being provided by one of the other women in his life. He's only had, I think, maybe 3 visits that I can remember off the top of my head where he has cared for her 2 or 3 hours. So there's no pattern that he can even care for that child for 1 day by himself.
Thank you, Ms. Farr. Ms.
And
Winkles,
Your Honor,
and then Mr. Anagnostou.
Yes, Your Honor. The issue with overnights is I think throughout this trial, we've seen some credibility issues from Dad. We've seen some definites as if he says they're definite, and they're not. And the credibility issues are a really big concern because we're talking about a home with a registered sex offender. We're talking about a mother who was willing to essentially turn off the court, and granted, she absolutely stayed, and more power to her. But the fact that she was very, very concerned with getting to her son on time, she seems like she's an excellent mother, but very devoted to her child. That is concerning in that this child doesn't have such a devoted parent to watch out for her. And should Dad take the child to that location, the protection will be by the person that normally protects this child when they're in Longview, which is his girlfriend, would probably most likely be protecting her son. If anything should happen, and not to say that it would, but if anything should happen, my guess is that the first order of business for that mom would be to protect her child, not to protect this child. Additionally, overnights are really problematic. He has one other place to go, which is grandma's house. Grandma has, the guardian ad litem noticed a number of issues with grandma's house as well. But mainly grandma's house is, grandma's an enabler. Grandma's house is very small. Dad can't be with the child there. The room is too small. You saw just a single bed. Really, grandma is going to be the one to take care of this child. And that's great. The grandma has some sort of input, but to give Dad overnight so that he can essentially use them to give the child to somebody else doesn't work. Really, the daytime visits force Dad. They force him to be present in Longview and have no other outside influences. When he takes that child and he goes somewhere else with that child, somewhere comfortable, his house, grandma's house, that's where Dad can play video games. That's where Dad has all kinds of other things that he can do. But when he's stuck in Longview, he's, aside from the one friend he somehow managed to meet and form a relationship with, and that was a little problematic. Aside from that person, he really has to focus on the child. He doesn't have a choice. He's going to stay with the child and be with the child in the area, find activities for them to do. They go to the park. They do things that really are very beneficial to this child. If he is in a comfortable situation of his own, his comfortable home, or his girlfriend's home, or his grandma's home, the likelihood is he'll just revert back to doing what he did before and is go in a room, play on his phone, play video games because he's comfortable there. It doesn't make sense when Dad hasn't done any of the evaluations. He hasn't done anything to change where he was when the emergency guardianship was entered. He's done absolutely nothing to change that type of parenting until he has a real parenting class. And you remember the testimony, he took a test, didn't have a test, until he does an actual parenting class in person. And it would be really, really nice to see either a substance abuse evaluation or DV. My clients would ask for no overnights. Once he's done those and he's shown some sort of active behavior to see his child. So something that shows he's not just stagnating and letting things go on around him, but that he's showing some sort of drive to see his child. At that point, sure, overnights. But for right now, Dad has done really nothing. He's just sat here and let everybody else take charge again.
Thank you. Mr. Anagnostou.
Yes, Your Honor. The circular logic is inappropriate. So all I can say. What they're saying is you haven't taken care of the child for the last year, therefore you can't take care of the child. Well, there's been an order in place that he only gets day visits, and he has complied with that. So they're coming to see, Your Honor, he hasn't had any overnights, so he shouldn't have any in the future. Well, what are we supposed to do? We've been here in court, trying to get this to move forward. So he can take care of his child. This is you heard the testimony. Grandmother's residence is where Kai moved him and his sister, my client and his sister, when they were little. Apparently he didn't take care of them. He turned them over to grandma. That's just not logical. As you indicated, it kind of takes a village to raise children, and he has resources. He doesn't have housing. And this is the best he can do, is to rely on the community, the village, for some housing while he gets on his feet. But he's going to be doing the care. You saw the pictures. He and Jaylyn are absolutely close. He'll be there for the whole weekend. He'll be with Jaylyn. He'll care for her, get her up, dress her, bathe her, whatever she needs, feed her at grandma's house. And yeah, maybe grandma's going to be there and involved, but that's the best he can do at this time. And that's the best for him and Jaylyn moving forward. And that's what I'm continue to look at is, Jaylyn needs access to her father, free access to her father. This coming up on weekends 4 times to exercise just a few hours, having to spend the money on gas and potentially a room. I think we should move forward and allow him and Jaylyn to further their relationship.
And Your Honor, just one brief, very, very, very brief. My clients are very concerned with the fact that he was in Longview last time on, I believe it was July 7th, and left the child at the house of his friend to go to 420 holiday. Now, granted, he denied that, but Chipotle and things were also on there. And that is their fear. He left the child there because he went to a weed store. He said he would never take the child there. And I believe that, considering I think you have to be a certain age. I'm not quite sure, but I would assume so. That's a concern. This is visitation, and he shouldn't be leaving the child really with anybody. The child should always be with him.
All right, thank you. Well, I had thought about the possibility of overnights and had given some consideration. It was very minimal in preparation for today's oral decision sharing. So there's arguments on both sides to allow overnights. The one thing that gives me pause is one is the marijuana use issue that has not necessarily been directly addressed through any type of evaluative process. The anger management issues have not been addressed via an evaluative process. And I still have lingering doubts as far as the child going to Ms. Harrington's home. I know everybody testified that has not happened. And I have concerns that it either has or may occur just because of the relationship, the length of the relationship, where they live in conjunction with where he works. So I think that all leads me to believe and conclude that I'm not going to change it at this point as far as the visitation. It'll continue status quo. The parties can certainly bring a motion if they want to address it at a future time. To provide a little clarity as far as the start time and the location, from what I understand, there is not a specific location. There's not a specific time that when the exchanges to occur. Is that accurate? Ms. Winkles?
Can you phrase that a little bit differently?
Sure. I thought there was a request related to for a specific time for the visits to occur and a specific location for it to occur.
That's it, Your Honor. Yes. They want a specific set time. So if he's 20 minutes late, it's too late. Not an hour, 20 minutes, 15 minutes would be okay. If he's, everybody can be a couple of minutes late, but nothing like an hour. At this point, there is no set schedule. It's at 10, they need to be there, but they wait.
And that's on Saturday morning?
That's Saturday morning, yes.
Okay. And is it at their home or is it at a separate location?
It used to be at their home. It's not at their home anymore. I believe it's at the pizza. Is it still at the pizza place? It's at a pizza place.
This was raised on temporary orders, Your Honor, and was specifically denied. The parties were instructed to communicate about the exchanges. And so if we're going to leave everything the same, it should stay the same. And they want to hammer my guy because of traffic and various other things, especially in the winter months. It was very difficult for him to get up here during ice storms and stuff. and he needs cooperation on their part. And, you know, they were unwilling to do that. And the court said, no, this is what we're going to do. And this is the order that the court entered. And so if we're keeping things the same, it should stay the same.
Thanks.
And
All right.
Your Honor, just briefly, I think the child is young though, and sitting in the car for that long is also a bit of a problem.
Okay. So I think a 30-minute wait time is appropriate. If after 30 minutes he has not arrived with the child, then that's long enough to wait. And so that what that means for Mr. Ludwig is that we'll probably leave an extra hour early to make sure that he's on their time, to make sure that there's no untoward events occurring. And, you know, obviously if there's a big pile up on the freeway and he can't get around it, I mean, that's things like that do happen. And if there's communication, there should be some flexibility, but unless there's a 7-mile backup and that's, verified through police or through news reports or through traffic cams or what have you, I think a 30-minute wait time is reasonable, and that the location should be at the pizza place on exit 49. That just provides more certainty to everybody, because that's good for the child to know, specific times, so that she can count on that consistency and stability. So it'll be at that. It sounds like the parties have been meeting at 10 a.m. So up to a 30-minute wait time, and there should obviously be good communication. And if it's 31 minutes, nitpickiness isn't going to get people very far. It should be a reasonable time frame. 30 minutes is kind of the cutoff, and there should be communication leading up to that. And so the idea is that Dad will leave with plenty of a buffer to make sure that he's there present.
Then, Your Honor, if we are making changes, can we change the return time? Because right now, I believe it's 5 o'clock, which is about the time that Jaylyn should be eating, and it conflicts with their meal time. So my client should be able to feed Jaylyn a dinner before he returns her on the weekend. So we would like to keep her at least till 7.
I think an earlier dinner time is fine if he can do whatever he wants to as far as feeding his daughter 7 o'clock and then returning, getting home around 8:30 or 9. I don't think that's in the best interest of the child. So I'll leave that return time similar and the same, no change.
I'm not.
You asked for a change for the return time at
Right.
7 p.m. and I denied that, and it'll stay at 5 p.m.
All right, on both Saturday and Sunday.
Yeah.
Yeah. Okay.
And are we doing did I miss that? Are we doing the every weekend or every other weekend?
I'm at this point, I'm not going to change the frequency. Okay. Anything else from the parties as far as clarification?
My client's waving her hand, and if she can ask, I'm not sure if Your Honor would allow her to, because we're not in the same room. It makes it a little difficult.
Yeah, that's okay. Go ahead, Ms. Ludwig.
Your Honor, I don't want to cut any time short off Jaden's visit. It's actually 9 to 6. So I want to make sure that is clear. He picks her up at 9 in the morning and can bring her back at 6 at night.
Okay.
I just want to make sure that everybody was aware of that.
Yeah, that's good. I appreciate that. I think that kind of addresses kind of one of the concerns Mr. Agnostu raised, and so that provides a little more time. So,
And then on Saturday nights, if he has something special he would like to do with her, that type of thing, he could just set it up with me, and he could keep her for a little extra longer if he'd like.
Okay.
So just have him communicate with me.
Right. So it sounds like the parties are aware that the visit times are 9 a.m. to 6 p.m. Okay, that's great. I appreciate that. As far as a presentation of an order memorializing today's decision, we could look at a Friday at 8:45 for presentation.
Is that your 8:45 slot?
It is.
Perfect. Okay, I have a trial pretty much every single week, unfortunately, but it looks like they all start at 9. I'm assuming they're going to be on Fridays. I can do the 27th. I have a trial, but as long as hopefully we'll be done before that.
Okay, Mr. Adagnostu. And that's just kind of a backstop if the parties can't come to an agreement as far as an order, but we would set that as a presentation date.
That works. That's fine.
Okay, we'll set it for that date. Certainly, if the parties come to an agreement, that you can submit a joint order ex parte, and we can sign off on that. Otherwise, we'll see everybody on the 27th of October. Next, I'd like to call the guardianship of Jaylyn Sloan, which is cause 22-4-41208. There we have Ms. Winkles present and also Mr. Anagnostu. So just want to touch base with the parties. I received just a little bit ago proposed orders, and I assume, Mr. Anagnostic, did you receive those just a moment ago also? Oh, mute's on.
Sorry about that. Okay, there we go. Sorry about that. I think I received them yesterday morning. It might have been late on Wednesday night, but I haven't had a chance to look at them.
Okay.
And that's on me. I apologize to everybody. I'm a little backlogged, a lot backlogged. So it wasn't until about 2 days ago that I remembered, oh no. So
Okay.
that's on me completely.
What's your proposal as far as timeframes where we could choose a time where everybody'd have an opportunity to review the documents that have been submitted? Would 1 week be sufficient, Mr. Anagnostic?
Well, I was going to ask for 2, primarily because my client lives in Central Oregon, as you recall. I got to get him the documents. I haven't had a chance to do that yet.
Okay.
And then we got to set some time next week to review them and go over them and see if we have any objections.
Okay.
I don't know that I'd be ready by next Friday.
Okay. So we have 2 weeks would be, I think, is Friday the 10th closed? Is that a court observed holiday for Veterans Day?
It is.
So let's not come on that day. How does the 7th, let's see, 17th, I'll be in Seattle for a meeting. I guess that puts us to, well, it's the 24th. December 1st, how does that look?
December 1st is fine for me. And then, and I will check to make sure that the guardianship, the emergency guardianship is still in place until that time. Because that's the only concern, is that there's, not having a gap.
And
Okay.
as I recall, the last order that was entered said it would stay in effect until this case was resolved. So
I think that's what I put, but in any case, I'll fix that because it's
That's
my error this time.
Okay. And
That's fine.
and December 1 works for you, Mr. Anagnostic?
yes, it does, Your Honor.
Oh, you know what? I just looked at my calendar. Sorry, December 1st, I'm out of town and I'm not present. Gosh, I'm sorry. The 8th of December?
That works for me as well.
That's fine with me.
Okay. All right, good. Thanks for your patience. I appreciate that. So let's set the matter over to December 8th. We'll have everybody have an opportunity to look at the proposed and file any objections, and we'll come back on the 8th and see what we can do to get those orders entered.
All right. Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you both.
All right, we're here this morning for a presentation docket on the matter of guardianship of Jalen Sloan. Cause number is 224004112-08. So we'll check to see if all parties are present. I see Mr. Anagnostic is present and Ms. Winkles is present. There's the camera on, so Mr. Anagnostic is here. Welcome.
Hi.
Hi. And Ms.
Apologies, Your Honor. This is actually Ms. Winkle's legal assistant. She may be having some technical difficulties, so if we can just pause for a second while we try to get her online.
Okay, that'd be helpful. Thanks. Let me touch base. I apologize. I don't know the name of Ms. Winkle's assistant. I just wanted to double check with you to see if there's an option. Maybe Ms. Winkles could dial in or use a phone to make contact into the Zoom.
Judge Evans, Dave Nelson. I'm now working at Aaron Winkle's office.
All right.
It appears that she may be ill this morning and is not able to make the hearing. So from our office, we're asking for a set over if we could do that.
All right. Let's hear from Mr. Anagnostic.
No objection, Your Honor. I understand that happens.
Yeah.
Thank you, Mr. Anagnostic.
Yeah, let's double check. Next Friday is the 22nd at 8:45. Would that be a feasible date?
We're checking our calendars here.
It's right before Christmas, so I know that means
Right.
perfect date.
I can be here. It's not convenient, but I can be here.
I mean, we could set it over to the 29th, the
I
following.
think the 22nd would be better. I think the week after, actually, gonna be out, yeah, so.
Okay, so for Mr. Anagnost, that works. How does that look on your
Let's
end?
say going to be 8:45 though.
8:40.
We could do it before the trial.
Ms. Winkles has a trial starting at 9, but we think we could get this done at 8:45 as long as it's taken first on the
Yeah.
docket.
Yeah, my understanding right now, this would be the only matter that's docketed for that morning. So we should be, and the number of objections is low, so I think we should be able to take care of it on that morning. Okay, so we will move it to the 22nd at 8:45. Thank you.
All right, thank you.
You're on record?
Perfect, thank you. Good morning, all. I'm Judge Evans. We're here for a presentation docket related to the guardianship of Jalen Sloan. I see Mr. Anagnost is present, and I see that Ms. One moment. Hi. I think they're there for the trial. So everybody that here is for presentation is on presentation and the trial people. Yeah. Yep. Pardon the interruption. Okay, Ms. Winkles is here, Mr. Anagnost is here. Proposed orders were filed and there was objections to the same. I've reviewed those. And let's maybe just go ahead and just talk about those briefly. So starting on the proposed order, so I'm looking at the proposed order that Ms. Winkles prepared. And the objection, we're looking at paragraph 9, which is on page 4, I believe. Let me just jump over 1 second. So there is an objection to a couple of different things as far as the word need on line 3. So it reads currently that the parents, Jaden Ludwig and Kimberly Sloan, are not willing or able to provide. Mr. Anagnost indicates that it should read simply Kimberly Sloan is not willing or able. I think that was what you were asking, correct, Mr. Anagnost?
Right, Your Honor.
And then, okay, and then you go on to indicate.
Your indication that my client was willing but not currently able. And that's why I objected to him being out of that first paragraph, but I added that clause into the beginning of the next paragraph. That my client, Jaden Ludwig, is willing but not able. And
Right.
I believe that was your ruling.
Okay. Ms. Winkles?
Yeah, so I understood that he wasn't willing or able to provide the care. So it's not just that you're willing to do it, it's that you're willing to do it to such a level as the child needs. And that was where the kind of the contention came from. I have no problem if it is very expressly very expressly worded that he is unable to care for the child, but it needs to be expressed. It needs to be something that, because that's the basis for this. Otherwise, the father would have the custody of the child. So I'll defer to Your Honor on that.
Thanks. So I'm gonna go with Mr. Anagnostu's suggestion here, and it'll read the parent, and then I'll line out Jaden Ludwig and the word and I'll say Kimberly Sloan is not willing or able to provide support care, etc. And then we'll add that second line that says the parent, Jaden Ludwig, is willing but not able to provide parenting functions at this time. And I think I can interlineate that. So we'll do that. Then on paragraph 12, so I'm not making a finding of abandonment nor a finding of neglect on lines 3 and 5. However, on line 8, I am going to keep the neglect finding there, and also the substance abuse, I'm keeping that in, and lack of emotional ties. That wasn't objected to. The only question I had was on the emotional physical problems. Is Jaden Ludwig and Kimberly Sloan had long-term emotional physical problems that gets in the way of their ability to parent. I wasn't quite sure if that was something that was explicitly stated in my ruling, so I'm not sure.
And for the petitioners, Your Honor, that was kind of the crux of the case, is that he needed to have a mental health evaluation and have some treatment for that. And they went through his past history essentially up until today. And the lack of getting this evaluation and the lack of any treatment or any addressing these needs, addressing the fact he's not supporting himself. And that was the entire crux of essentially their case, that underlying behavior with the substance abuse. We would prefer to keep it in such that it's identified for the court, because that is, and when he comes to terminate this, hopefully one day, that we can address those, because obviously to get over that, you address what basis and what that led to the guardianship in the first place. And that is something that still needs to be addressed. So we'd ask for it to remain, but again, we defer to your honor on that.
Thank you. Mr. Agnostic?
Yes, Your Honor, there was no finding with regards to my client of emotional or physical problems. And this is, it was upsetting even through the trial and through temporary orders because they kept indicating that, well, he has emotional problem, he needs a full evaluation. And we kept saying, pay for it, I'll do it. There was no evidence presented, and there was no finding by Your Honor that my client had any emotional issues that prevented him from having custody.
Okay, thank you. All right, so on paragraph 12, I'm striking the abandonment and the neglect on lines 3 and 5, I'm keeping the neglect on line 8. I'm striking emotional or physical problem on 9 and 10, keeping substance abuse there. Then we'll turn to paragraph 13. The objection there was related to child support. I don't think I made a specific finding related to child support, so I'm interested in striking that, but I want to hear from Ms. Winkles first.
Yes, the reason that we put child support in there was because when the state gets involved, and it will eventually, because it's going to be administrative, my clients were actually trying to help out Mr. here. They don't want him to be in a hole, and the state will apply child support. And if you look at the child support order, they're asking for the absolute minimum of support, which is essentially the $50. I don't think he has a job at the moment. They're very interested in him getting on his feet versus paying them $100 here, $100 there. Whatever Your Honor wants to do, again, we defer to Your Honor. This is their child. And even though he's the opposite, they really would like him to get on his feet. So whatever the very minimum amount of child support that can be assigned, they would ask that it be that way so that he can use that money to find his way.
Thank you. Mr. Anagnostic?
Yes, Your Honor. In their petition, they indicated that there was no request for child support. They checked the box, they indicated it. They never amended that. We never talked about it at trial. It just wasn't discussed. It shouldn't be ordered. And my client, if the state attempts to backdate some amount of support, that's not part of this case at this time. He'll deal with that when it comes up. But it was never requested, never presented, never discussed. It shouldn't be part of this order.
And my clients are fine with that. They were just trying to do a good thing here. So if they want to go have it go through the state, then unfortunately it'll be out of their hands.
Okay, all right, thank you. So I'll strike paragraph 13 as it wasn't in the petition, and I appreciate the good motive behind Ms. Winkler's clients. Then on paragraph 20, the next objection related to visitation. So lines 14, 15 is the concern by Mr. Adagnostou related to distance rejection or distance related to Miss Harrington. So okay. So I just want to hear from Ms. Winkles. You've read Mr. Adagnostou's objection. What's your position?
Yes, can you read that objection out loud? Just because
I sure can. So the objection, lines 14 through 15, says visitation restrictions, not an order made by the court. And specifically, Mr. Adagnostou, this is the language as it reads currently, and then I'll read the language as he proposes it. Visitations restrictions include the father is prohibited from allowing the child to be present in Michelle Harrington's residence or come within a 1,000-foot radius of the same, or to be within 1,000 feet of Michelle Harrington's son. Any travel outside of Washington state shall be disclosed to the guardian at least 24 hours in advance. That's the full paragraph presented. Mr. Adagnostou's proposal is that it reads, visitation restrictions include the father is prohibited from allowing the child to be within 1,000 feet of Michelle Harrington's son, period.
Yes, the reason that we did not agree to this is because if you're in a 2,000 square foot house and the child's there, and the father has a history of, as testimony was a history of playing video games and letting the child run around, that means that they can be in the same house, which puts that child at risk. 1,000 feet is not enough, given the size of some of the homes, given the size of some of the yards. It really means that the child and this man that was a registered sex offender
can be in the same residence, and that's not acceptable. So we would ask that it state that, there is a prohibition on the child being at that residence. Dad wants to take the child, up into Oregon. It makes sense to disclose to the guardians that that's where they're going. There was a lot of testimony given, and who knows, only dad knows where and when he took the child anywhere. Grandma's house is fine, but this is the problem, is the registered sex offender, and to make the language so succinct and so expressed that nobody can find a loophole, nobody can leave this child unattended where she might be injured.
Thank you. Mr. Anagnostic.
Yes, Your Honor, this just was not part of your ruling. And we understand there was a lot of discussion and with regards to Miss Harrington's son, and we understand the concern, but he can't be around children, and my client is not going to let Jaylyn be around her son. But I mean, the main point is we never discussed this. It wasn't part of your ruling. I don't mind. I understand the court could say he's got to keep if he ever gets visitation down in Oregon. Currently, he's still not having it. It's up here, but that it'd be 1,000 feet away from her son. That Jaylyn never be around her son. I mean, I think that's probably part of his her son's DOC requirements anyway. But so we don't mind that, but the rest was just not part of your ruling, and so we object to that.
Okay, all right, thank you. One question with the language, it says Michelle Harrington's son. Does she only have one son?
It's a great question. I don't know, but I think so. But we know which son she's talking about. In fact, I think as part of the evidence they presented, his DOC requirements. It had his name on it.
Thanks. Ms. Winkles?
I believe she does only have one son. I can't remember for the life of me what his name is at this point in time, and I wish I had put his actual name down now. I think my client might know his name if my client's on here. But if not, I believe she does only have one son, but I can't tell you 100% for certain.
Ms. Crape, do you know?
I do not know his full legal name. No, I believe it. I thought it was Richard, but I could be wrong.
Let me just pull up my notes from the hearing and see if I have any indication there. So let's go. Well, maybe if I can find it in my notes, I can add that. So here the concern is related to the son who's a registered sex offender who lives within the home of Miss Harrington, and we understand that Mr. Anagnostic, I forgot your client's first name.
Oh, Jaden.
Jaden, yeah. There's Jalen and then Jaden. Okay, thanks.
Right.
So Jaden is dating Michelle Harrington. The concern is that the child would be there in the home, potentially unattended, and there has been concerns related to neglect and not caring for the child. So the restrictions, as far as the restrictions on visitation, I'm going to include that. I am striking the portion, any travel outside of Washington state shall be disclosed to the guardian at least 24 hours in advance. But everything else, I'll include that. And then just for clarity, after when it says the father is prohibited from allowing the child to be present in Michelle Harrington's residence, or the child coming within 1,000 foot radius of the same. So I'm just going to specify, add the child, add a little greater clarity, and then also to be within 1,000 foot radius of Mr. Harrington's son, Ms. Harrington's son. So I'll phrase it like that. Then the next portion is a paragraph 22 related to the child support and the like. So we already talked about that. So just want to make sure that everybody's comfortable with my prior ruling, and then I'm just going to strike that portion.
That's absolutely fine, Your Honor.
Okay, let's strike that. Okay, with that, I think that addresses each of the issues. So we have the child support order that I will not be entering, nor the worksheets. I do have an acceptance of appointment of guardian document that's to be filed, and also acceptance of appointment of guardian conservator and letters of guardianship document. So I'll make sure those are filed.
All right, thank you, Your Honor.
Okay, anything else from either party?
Not at this time, Your Honor, no. Don't think
No.
so.
And just so Your Honor's aware, I will run up there right now. I believe I'm in a trial with you right now.
Right, it'll take me a moment to shift over also.
Okay.
Your Honor,
Yes, Ms.
thank
Gray.
you much for your time and this. I appreciate your understanding. Thank you, Mr. Agnosta.
Sure. Have a Merry Christmas, everyone.
Thanks.
You too.
You too.
Bye.
That was the last time this case had any hearings in this court. On December 22nd, 2023, Judge Evans signed the order appointing Dad's parents as the child's guardians, and because this is a full guardianship and not just an emergency one, the order won't expire until Jaylyn is 18 in March of 2037. But Dad must not have been happy with Judge Evans' decision, because a month later he petitioned the court to declare him indigent, and on March 15, 2024, the court appointed him an appellant attorney. It's not uncommon in an appeal to change attorneys to someone who specializes in those sorts of cases, so I'm not surprised that Kurt was replaced. From the dates in the file, it looks like the appeal was originally sent into the court at the end of February 2024, and they received their perfection notice from the appeals court on March 18th. A perfection notice lets you know that your case is officially in the appellate system, that the lower court's power over the case has been stayed, and that the Court of Appeals is now handling things. 15 months later, on June 24th, 2025, the case was heard by the Court of Appeals. They don't show the results of the appeal in Odyssey, but we can surmise that things didn't go the way Dad wanted. Because 2 months later, in August of 2025, Dad petitioned the Supreme Court to review the case. However, in October, only slightly more than a month after filing with the Supreme Court, Dad appears to have voluntarily dismissed the case. The final entries in the case file seem to back this up. In mid-November 2025, the appeals court sent in their decision after ruling on the motion to dismiss. And finally, the judge ordered the destruction of any exhibits. There have been no other entries in this case since. From everything I can find, the grandparents should still have custody of the child, and Dad has visitation. I tried to confirm that she was still with them through social media, but aside from Grandpa, the rest of the family haven't really used it in years. Even Grandpa keeps things understandably private, so I wasn't able to learn much. There were a number of photos of the family with the child from October of 2023, which is almost immediately after the trial. The final time I spotted her was 14 months later, the following Christmas in 2024. I assume she's still with them. There are no other public photos to be able to tell for sure, but everything I've seen in Odyssey also seems to indicate that. Frankly, I'm relieved to know that this little girl will continue to live in a loving and stable home with her grandparents. I do hope that Dad will get his shit together and start showing up for his daughter so he can participate in a more meaningful way, but I take a lot of comfort in the fact that his daughter's life won't be upended if he fails to do what he should. Thank you for watching this epic case with me. Bye!